Good morning, everybody. Happy Thursday. Welcome to TCF Live. My name is Dan Soul. I will be your guide through our next 3 hours through Courtlandia. We'll start our day in Allegan County, Michigan. This is Judge Skocelas.
I believe he's present. We should be able to proceed to sentencing.
Sir, how long have you been in custody?
What was that, sir?
How long have you been in jail?
I'm not too sure, sir.
Mr. Klein, anything on behalf of Mr. Montague?
Yes, Your Honor. Mr. Montague, I believe when he pled to a circuit court probation violation on April 9th, he had been in jail for 14 days at that point on the assault and battery as well as the probation violations. He's remained incarcerated since that time. He received 150 days with credit for 80 days served on his underlying probation violation in circuit court.
Recommendation in this case was for a jail term with credit for time served. Will impose a jail term of 5 days in the Allegan County Jail. You will have credit for 5 days already served, and to clarify, this will be non-consecutive to any other sentence. Given that, I'm going to waive the fines and costs that I'm able to waive. I'm unable to waive a state cost of $50 and a crime victim right fee of $75 for a total of $125. It will not come due for payment until at least 3 months out. So with that, sir, you're all set today. As the plea agreement called for, your sentence was jail with credit for time served, and I've waived all the fines and costs that I'm able to waive. Okay?
Thank you, Your Honor.
Thank you. Thank you, Mr. Klein.
You bet. I'll be in touch, Dylan.
Yes, sir. Thank you.
Thank you.
Corey Leshman, can you hear me? You have to unmute.
Hello?
There you go.
Okay, yeah, sorry.
This is file 260087FY, People versus Corey Anthony David Leshman. Here today for sentencing. This was originally a felony case issued by the Allegan County Prosecutor's Office on a charge of assault by strangulation or suffocation. Prosecutor's Office also indicated Mr. Leshman was a fourth or subsequent habitual felon. Prosecutor's Office then dismissed the felony charge they issued against him. On the 2nd of April, he entered a plea of guilty to a misdemeanor charge of domestic violence second offense. At that time, there was a request to set this for sentencing at a later date for crime victim rights purposes. Reviewing our file yesterday, we have nothing in the court file. Is Stephanie Daly present, or has she filed any type of impact statement with your office, Mr. Duffield?
Thank you, Your Honor. We have no impact statement, and I don't believe that she is present. Just so the court is aware, I believe alcohol use was a factor in this one. Thank you.
Any request for restitution?
No restitution request received either, Your Honor.
All right. With that, Mr. Leshman, this is your chance to tell me anything you would like to for sentencing this morning.
No, well, I was going through something. My mom had just passed away, and my brother's death anniversary was coming up, and I'm not normally a drinker ever, and I drank, and it scared me, and I won't ever do it again because I don't want like that, and I apologize to her and everybody for that.
Ms. Klein, on behalf of Mr. Leshman for sentencing.
Thank you, Your Honor. Mr. Leshman has been so sad about everything that happened that day. As he indicated, he was dealing with some emotional issues because of the loss of his mom and the anniversary of the death of his brother. And he knows that alcohol is not something that's acceptable. It's not a way to forget things. It's not a way to deal with trauma and sadness. So I would ask you just to consider mandatory fines and costs, Your Honor.
Mr. Leshman, this is nothing new for you. Your criminal record goes back 26 years. You start off with cases through the juvenile court system. And then on March 22nd of 2010, you were convicted of a felony charge of home invasion in the first degree, went to prison for that. April 21st of 2006, were convicted of a felony charge of possession of methamphetamine. March 20th of 2009, convicted of a violent offense for resisting or obstructing of a police officer. March 17th of 2010, pled guilty to another drug charge. On January 2nd of 2012, pled guilty to another drug charge, a charge of possession of methamphetamine, operating while intoxicated, second or subsequent offense. Went back to prison on that for 18 to 24. Came out of prison April 6th of 2017. Pled guilty to another violent offense of domestic violence. February 7th of 18, pled guilty to another home invasion charge. This one, home invasion in the third degree. On the 22nd of July of 2019, pled guilty to another drug charge, this time for attempted possession of methamphetamine. Following year, March 16th of 2020, another felony charge of possession of, can you mute whoever's speaking, Kelly? Thanks. March 16th of 2020, another drug charge, another charge of possession of methamphetamine. So Mr. Leshman has 7 prior felony convictions. Reviewing his local record, he also has 7 prior misdemeanor convictions. This is his 3rd assaultive offense. He has 1 for resisting the police, a prior domestic violence in 2017, and now this conviction here. Reviewing the facts of this case, doesn't appear to be motivated by any more than the most common thing we see for domestic violence. It's a fight over a cell phone. There was a fight between he and Stephanie regarding changing her passcode on her phone. He got upset, grabbed her by the neck, tried to headbutt her. So for the reasons as stated on the record, specifically his extensive criminal history as stated on the record, also the facts of this case, will place you on probation for a period of 2 years, and that will be with counseling services as directed by the probation department. On this charge, given your extensive history of methamphetamines and alcohol, will indicate that you not possess or consume any alcohol, marijuana, or illegal controlled substances while on probation. You will have the authority to check you for that here at the probation department, have you checked by the police at your home, or have you physically monitored for alcohol consumption at any point while on probation. There is a protective bond in place indicating no contact with Stephanie Bailey that will also be continued as a condition of your probation. Probation department is going to have the authority in your case to provide counseling services both for domestic violence and for substance abuse. On the charge of domestic violence second offense, first of all, there is a $720 oversight fee for that term of probation. The fine is $1,000. Court costs are $300. State costs and fees are $125 for a total $2,145. No indication of restitution is being requested for any injuries or damages. None is being requested at this time. Regarding the fines and costs and oversight fees. You will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. As this is an assaultive offense, you have no right to early discharge from probation on the probationary sentence. Finally, for the reasons as already stated on the record, I'm imposing a jail term of 30 days in the Allegheny County Jail. You will have credit for 1 day already served. You will need to report to the Allegheny County Jail next Friday, May 8th at 3 o'clock in the afternoon, or after that time, a bench warrant will be issued for your arrest. Will indicate that I have no objection to work release if you qualify under the jail's work release program. Our probation department is going to contact you on the telephone to set up your probation order. What telephone number can they reach you at this morning?
You have to unmute.
Okay, you are free to hang up from the court proceeding. Be available at the telephone number you just gave us. The probation department will be calling you at that number shortly. Good luck to you, Mr. Leshman. Thank you, Ms. Klein.
Thank you, Judge.
Thanks.
Ms. Silverstein, are you there?
Yes.
All right. And are you here for Smith?
Yes.
Okay. Smith, can you hear me okay?
Yes.
This is file 260802 FY, People versus Jacob Jeffrey Smith. Originally charged in this case with a felony offense through the Allegheny County Prosecutor's Office on a charge of assault by strangulation or suffocation. Count 2 was a charge of domestic violence. Prosecutor's Office then dismissed the felony charge they issued against him, and on a misdemeanor charge of domestic violence, accepted a first offense deferral, which will also result in a dismissal of this at the end of that 1 year period. The time of the plea on the 9th of this month, the prosecutor's office requests to reset this for a later date for crime victim rights purposes. And we've had nothing come through the court file as of yesterday. No one is in the courtroom today. Mr. Duffield, is Jordan Thomas Joseph Kubani present, or has he filed any type of impact statement with your office?
Thank you, Your Honor. He is not present in our office, and we have no formal impact statement received. Having reviewed the file, no indication of either drugs or alcohol being involved, and we have no restitution request.
And recommendation regarding contact with Mr. Kubani while Mr. Smith is on probation.
I would advise that the no contact provisions remain in place and that the parties all through the probation department if they deem it fit.
Mr. Smith, this is your chance to tell me anything you would like to. We're setting up the terms and conditions of your deferred sentence, and this is your chance to tell me what you'd like.
Would I be able to get that lifted if he were to contact the courts?
If he contacts your probation officer and recommends it, and your probation officer recommends it, they will then send something to me recommending it, and I will go along with that. The main thing they're going to be looking for is that you've already gotten yourself engaged in some type of counseling, so this doesn't happen again, because if it happens again, under Michigan law, if you do anything like that, I'm required to kick you off this deferral and a conviction will be entered. So we're trying to make sure this goes successfully for you. But yes, if he recommends it and your probation officer recommends it, I think I probably every single time have gone along with that. But the main thing is going to be that you show some effort as well by getting involved in any kind of counseling that they recommend for you. So, yep, that's the goal, is to get, this is your brother, I believe.
Yes, sir.
Okay, this is always the goal, to get you guys back together, okay?
Okay.
Anything else you wish to tell me for sentencing?
No, that's it.
Ms. Silverstein, on behalf of your client for sentencing.
We ask the court follow the recommendation of diversion at this time. Thank you.
Mr. Smith, as you're hopefully aware, the probationary term is for a period of 1 year. There is a $625 oversight fee attached to that. The court file is showing you released from jail on a $500 personal recognizance bond. So all of that is due, but you will have the entire year on probation to pay that amount on a monthly payment plan set up through the probation department. Probation department is going to have the authority to require counseling services. Given you guys are brothers, it'll be a little different than it would be for a husband and wife or a boyfriend girlfriend type situation. It's essentially more geared towards anger management, so this type of thing doesn't happen again. Again, the no contact provision of your bail is going to be continued into a probation order, so no contact with Jordan until further order of the court, which means just that I would have to sign an amendment to your probation order. You will be on probation to the court till roughly May 1st of next year, 2027. If you complete it successfully, the probation department will notify my successor judge, and he or she will send you a letter in the mail saying your case has been dismissed. And of course, that's what we hope happens. Mr. Smith, the probation department is going to call you shortly to set up this probation order. What telephone number can they reach you at today?
616-40.
After the court proceeding, be available at that telephone number, receiving a telephone call at that number from our probation department shortly. Good luck to you, Mr. Smith. Thank you, Ms. Silverstein.
Thank you.
On the telephone, what is your name? On the telephone ending in 0191, can you hear me? Mr.
Kyle
McBurney,
McCollum.
Oh. All right, Kyle McCollum. Can you hear us okay?
Yep.
Okay.
It's file 260179SD, People versus Kyle Wayne McCollum, here today for sentencing. In this case, on the 27th of March, he entered a plea of guilty to a charge of operating while intoxicated. As required at that time, I ordered a substance abuse assessment, and he was involved in an accident. I also asked the court staff and prosecutor's office to determine if there was any restitution in this case. Have received a substance abuse assessment, have not received any type of restitution request here through the court. Mr. Duffield, has your office received one?
We have not received any restitution information, Your Honor.
Okay, will indicate no restitution request has been received and none will be ordered. So with that, we are able to proceed to sentencing this morning. Mr. McCollum, I'm going to start off with a question for you because it wasn't real clear from the materials that I received. Are you currently on probation or parole to the Michigan Department of Corrections?
Yeah, I got transferred out of Arkansas.
Okay, so you are on probation or parole for how long?
Like 3 more years.
Okay, 3 more years. All right, a lot longer than we'd have you on probation here. Okay, so were you on probation or parole when this happened?
Yes.
What, if anything, did you do?
I've been talking to my probation officer up here, but so far nothing.
Not a thing, huh? Okay,
Not yet.
well, that's concerning, I guess. Go ahead.
Yeah.
Okay, Mr. McCune, on behalf of Mr. Montague for sentencing.
Sure, thank you. I spoke with Mr. McCollum regarding this matter. My understanding is that the probation department has not decided what sanctions he is going to face as a result of this offense, because he is being courtesy supervised here in Michigan, I think there's a little more of a process to determine what they want to do or what kind of marching orders the Michigan probation department is going to be given from the out-of-state originating court. But in any event, Mr. McCollum has not consumed any alcohol since this incident. He's certainly fortunate that he didn't hurt himself or someone else. He indicates to me he's employed full-time. He's a mechanic working on commercial vehicles. He supports himself and those that rely upon him. And he has committed to making changes to make sure he can comply with the terms of probation. Thank you. Thank you, Your Honor.
Thank you. Well, I was waiting to find out what exactly was going on with that to determine what the sentence would be. And if I was told that they have addressed this, they've engaged you in alcohol counseling services and done some kind of a sanction, that would be one route. Or unfortunately, in this case, they've done nothing. This happened back in September of 2025. Tomorrow's May 1st of this year, and they've done nothing. So I'm going to treat this as I would anyone else coming through and place you on probation for a period of 6 months. That will be with substance abuse counseling as directed by the probation department. Standard condition of probation: do not possess or consume any alcohol, marijuana, or illegal controlled substances other than those prescribed to you by a medical professional. They will have the authority to check you for that here at the probation department, have you checked by the police at your home, or have you physically monitored for alcohol consumption at any point while on probation. On this charge, they'll also require completion of a victim impact panel. Also on this charge, your driver's license, at least in Michigan, would be suspended. And I'm not sure what your status is, but a condition of your probation is going to be that you not operate a motor vehicle without a valid operator's license. The charge of operating while intoxicated, the fine is $500. Court costs are $400. State costs and fees are $125. There's a $180 oversight fee for that term of probation, and a $100 fee for the substance abuse assessment that was done through the court for a total of $1,305. Court file shows you released from the Allegan County Jail on a $500 personal recognizance bond. So all of that is due, but you will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. Finally, as to your probationary sentence, required to advise you that you are eligible to be discharged at the halfway point if all the terms and conditions of your probationary sentence have been completed at that time. So in your case, probation could be all concluded in as soon as 3 months. Also looking at your criminal record here, it looks like you pled guilty to another charge, assault and battery, on April 10th, which would be just a couple of weeks ago. Is that set for sentencing, Ken?
Assault and battery. I haven't done anything like that.
Okay, maybe I've got a mistake on this then. Okay, that's fine. So, Mr. Montague, Mr. McCollum, what the situation is going to be is this. The probation department's going to call you and they're going to set up your probation order. Tell them what's going on with your other probation. If the other probation department starts to set up things that are similar to what we're doing here, I would have no objection to having probation discharged here. I just want to make sure that one of these two probation agencies is doing something to address the issues here. So don't want to have you on probation for both, but I want to make sure that you're going through the same type of services you'd receive here. So let them know who you're
Right now, Your Honor, through my other probation, he put me on a alcohol monitoring bracelet for like 90 days. And then I'm also doing substance abuse treatment therapy.
That's what I was asking up front, and I didn't know that. All right. Well, at this point, let's do this. I'm going to leave this as is. The probation department here will have the authority to terminate probation if they feel that services are all being taken care of otherwise. So let them know everything that has been done, particularly the name and telephone number or email of your probation or parole agent, and that will assist them in coordinating services for you. Again, the goal is not to have you reporting to two different courts at once. Okay?
Okay. Thank you, Your Honor.
Probation department here is going to contact you on the telephone. What telephone number can they reach you at today?
918.
Okay, you are free to hang up from the court proceeding. Be available at that telephone number. I'm sending your file down to our probation department. They will contact you at that number shortly. And again, hopefully we can get these two probations combined sooner rather than later. Good luck to you, Mr. McCollum. Thank you, Mr. McCune.
All righty. Good morning once again, everybody. It's TCF Live. It's Thursday morning. Good to have you all here. So I don't know if you caught it, but Judge Skocelas said to one defendant, something to the effect of, when you talk to my successor judge. So I looked it up, and just like Judge Middleton, he is yet another one who is aged out. So at the end of this term, he is done because he has crossed apparently that magical line of 70 years old, where in Michigan you can no longer be a sitting judge. At least you can't run for another term after 70. So anywho, that's what's up with that. Let's go to Georgia, Fulton County, see what's going on with Judge McBurney this morning.
Okay, let's get back on the record in Mr. McWell's case. It's 25 SC 004117. And last week, Mr. McWell, you entered a plea. So I've accepted your guilty plea. I learned that this is a situation kind of near Greenbrier from June of last year. There was some issue with you and your car. I think it was actually Ms. Brown and her car plus the Watkinses, and you ultimately got out and fired some shots near a Bank of America. Fortunately, no one was hit, but I think a couple of vehicles were hit. Those are the trespass counts that I think you damaged some vehicles. We were holding off on sentencing. You have 3 prior arrests, including this one, no felony convictions. So, Ms. Smith, why don't you start for the state? Let me know what the state's recommendation is, and if you've got any victim impact statement from the Watkinses. I don't see anyone online, so but you may have important info to share.
Yes, Judge, starting with the recommendation in this case for counts 1 through 3, the state is recommending 5 years to serve 2 with the balance probated. For count 4, possession of firearm during, we're asking for 5 years to run consecutive. And then for counts 5 to 6, we're recommending 12 months to serve. For counts 1 through 3 and 5 and 6 to run concurrent, and of course for count 4 to run consecutive. Special conditions of probation, we're asking for the defendant to complete an anger management course, to have no contact with the victims, and to be gainfully employed. I did have an opportunity to speak with the victims who were shot at that were in the car, and also the victims of the people whose cars were damaged. So the people of the ag assault charges and the people of the criminal trespass charges. Starting with the Watkins, they did not want to be on Zoom or be in person. However, they did tell me that this was a serious crime, and they want the defendant to be held accountable because there was a child in the car. They just asked for updates after we got out of the court, but they did not want to be here. And as far as Ms. Wilcox, she is one of the people whose car was shot. She was inside of the car when it happened. I had a conversation with her, and she said that this has changed her life drastically. She still has a bullet hole in her car that she has not been able to get fixed. Her window was also busted by one of the bullets. She was able to get that fixed, but just not the bullet that's still in the car. She said that because she's not able to afford it, she didn't go to work for a while because she was scared based off of what happened to her. And she's just been trying to navigate life since it happened. She's been kind of taking it hard. I spoke with the other person whose car was shot. They were not in the car at the time. Miss Gordon, she said that she did not want to basically be a part of this process. She would like restitution. However, I have not gotten any receipts or documentation from her. But regarding the victims in this case, those are the statements that they've asked me to relay to the court.
Okay, got it. So 10 serve 2, balance probated with the conditions that you mentioned.
Yes, Judge.
All right. Mr. Fortis.
Thank you, Judge. We're seeking 10 years probation. We're also seeking first offender. I know that that's discretionary with the court, but when we did do the plea colloquy, he is first offender eligible, and you indicated you would just take that under advisement at sentencing. So I just wanted to make sure that the record was clear what we were seeking. I'm going to give you a little background. I'm going to give you why I think we're seeking this. I'm going to call his mom as a brief witness. But outside of that, Mr. McWell is 30 years of age. He's lived in Georgia his entire life. He has very strong ties in the community. He graduated high school. He maintains stable employment with Amazon. He's a law-abiding citizen outside of this. This was just kind of a one-off. We'll get to that in a minute. The incident kind of arose out of an escalating situation, not really for him, but for the driver of the car that he happened to be in. And I believe, the alleged victims in this case that were kind of jawing back and forth regarding some erratic driving. And depending on who you want to believe, whether it was the erratic driving by the vehicle that my client was in or the erratic driving by the other individuals in the other car. And that continued on, and we'll get to that in a minute. The evidence will demonstrate that really has not been conveyed to the court, in my estimation, correctly, in that the alleged victim actually significantly contributed to and escalated the confrontation. According to the police report, the alleged victim armed herself with a brick and then challenged the parties to a fight. This was in the police report. This is also statement witnesses that were in the police report. So the alleged victim in the case gets out of the car, arms herself with a brick, threatens not only my client, but threatens the driver. As I indicated, there was an independent witness that corroborated that the alleged victim threw the brick through the rear window of the vehicle, causing extensive damage and contradicting portions of the alleged victim's statement to law enforcement. So what ended up happening is that when law enforcement arrived onto the scene and interviewed the alleged victim in the case, the alleged victim indicated that there was a verbal altercation. That's all it was. What escalated the situation is when the alleged victim gets out of the car, arms herself with a brick, basically says, "Do you want to fight?" and then proceeded to throw the brick through the window. So when the police arrived on the scene, she negated that she threw the brick through the window. And obviously, and I've shown pictures to the state regarding the brick that did go through the window. And not only that, there were independent witnesses that were there that were there on scene and stated that she threw the brick through the window. So in essence, the alleged victim in this case was not truthful to the police. So it calls into question a lot of what she asserts happened in this case based on her ability when they arrived on the scene to not be truthful about what her actions were. Prior to the big brick being thrown, the encounter was verbal. I mean, that's all it was. And then she escalated it. And one would say, if she's so concerned that there was a child in the car, then which my client did not know that there was a child in the car, regardless, why would you escalate a situation and arm yourself and threaten somebody? And that's exactly what happened. He reasonably perceived, my client did, the situation is dangerous. Once the alleged victim armed herself, threatened violence, and then acted on that violence by shattering the back window of the vehicle that he was in. While he acknowledges his reaction may have been excessive and he accepts responsibility for the conduct, and that's why we're here today, the facts clearly show that this was just not a one-sided incident where Mr. McWell gets out of the car based on a verbal dispute and starts haphazardly firing his weapon. No individual was struck. There's no physical injuries by the discharging of the firearm. Mr. McWell, as I stated earlier, was unaware that there was a child in the other vehicle at the time of the incident. And I think that if I want to elaborate on that, as Your Honor will recall, I think at calendar call, when I had indicated that we were contemplating filing an immunity motion at that time. And I spoke with Mr. McWell at length about that because I think we had a meritorious argument. And I think that not only that we had the alleged victim in this case just not being truthful. However, we talked about was the force, was it reasonable in nature, number one. And number two is, I think that Mr. McWell felt, very bad about the fact when he learned that there was a child in the car and not what happened, but more or less what could have happened. So he decided to forego that route and move forward with accepting responsibility before that court. And that's what brings us here today.
So I'm curious, I'm looking at the original booking information just had citations, but there's a much more thorough affidavit from, seeing if it's a detective, some officer, who clearly had done some work on the case.
Yes.
It references one of the Watkinses with a brick. That person says, I didn't throw it. Mr. McWell turns himself in. You had mentioned that last week. He's like, hey, you need me. I'm coming in to talk. He said that the rear windshield had been broken by the brick, but then the officer says there was no damage to it, looking at an uploaded video, and Mr. McWell could not confirm ever seeing a brick in the vehicle. So we're not trying the case right now, but I'm just trying to work through. It's clearly more complicated than it initially sounded as I look at this affidavit, where we've got one of the victims admitting, I got out with a brick in my hand. She says she didn't throw it. Someone holding a brick is different from someone throwing a brick. And so I'm just curious. You sure can.
This was received by my client, and this is his car.
Okay, I mean, that's a car with a hole in a window. I don't know if it's this car, but okay.
Well, and I can also tell you that there were statements that were gathered independent on the scene, and the independent witnesses corroborated that the alleged victim in this case threw the brick through the back window.
Okay.
Okay. So regardless of what the police report may say regarding that, there is corroborated evidence through independent witnesses who were on scene that saw her throw the brick through the window.
Okay.
Okay. And as the court just alluded to, the court should consider that when Mr. McWell was contacted by law enforcement, he voluntarily went down there immediately to give a statement, knowing, number one, that he may be arrested, but certainly he wanted to let the officers know what his side of the story, was. And when he got there and gave his side of the story, he was subsequently arrested. He was subsequently given a bond thereafter, not at first appearance hearing. We did have a bond hearing before Your Honor. And during that bond hearing, Your Honor put Mr. McWell on an ankle monitor. I would say that he was on roughly about 6 months on that ankle monitor without incident. And then it was removed. During the pendency of this case, he completed 50 hours of community service. He did a firearm and gun safety course. And more importantly, all bond conditions from this court, as you stated from up there to my client, and talked about the seriousness of the event and that we could have been here for something much worse. You basically advised my client of what those conditions were going to be, including the ankle monitor, and he complied with each and every one of those conditions that the court put on him. While he was out on bond without incident, it demonstrates that I don't believe he's a danger to the community and that he is successful. He is capable of being successful in any type of rehabilitation conditions. The state wants him to do some sort of anger violence courses. We have no problems with that. I think that is warranted under the conditions. He does not know these alleged victims whatsoever. He's had absolutely no contact with them either before this incident nor during nor subsequent to the incident. There are mitigating circumstances to the facts. It's not just that there was a verbal altercation and Mr. McWell jumped out of the car and started firing. I think that one could say that he felt threatened at that point, just whether the response was reasonable or not, and what that reasonableness, is. A probationary sentence under the first offender it adequately punishes him, keeps the court with the tabs on Mr. McWell. I'm sure the court's heard all that before, and being accountable for whatever conditions, the court may put on him while protecting the community and preserving making him being a productive member of society as he has been by working and helping his family and supporting his family. He has a lack of criminal history. There's no felonies at 30, 31 years of age. He's demonstrated his ability to be compliant on bond, which makes, in my opinion, his ability to be compliant on probation. He's here to accept responsibility, not only through denial of filing an immunity motion, but certainly trial. And I believe that he's got substantial mitigation in this case, not only what he's done on his own, but certainly the facts and circumstances. And I don't need to tell the court that when the police come to the scene and you're not truthful on what your actions were, it leads one to believe or to think, what was really said or what was really done based on the purview that if you were to accept that from the alleged victims. So in this particular instance, Judge, what I'm asking for and what I think is warranted in this case is I think that the 10 years on probation with first offender, with the anger management component, if the court would like any additional community service, Mr. McWell would be happy to complete any additional community service as well, or any of the conditions that the court may deem appropriate. He is holding himself accountable for what happened. I just think that incarceration is intended for those who cannot be rehabilitated or who pose an ongoing danger in the community. I just don't think that his history nor his conduct nor the person that I've gotten to know demonstrates that. And if we think about what is really going to be achieved by incarceration, I think the messaging has been sent, number one. He's taken it extremely serious, number two. And then he gets out, however long that they hold him, and now he's without a job, without a home, without a car. And I mean, yes, those are conditions and circumstances of conduct, but the reality of it is that does this conduct, and based on all the facts and circumstances, does that really warrant incarceration in this case? And I think that and I keep bringing up that based on the veracity, when the police came onto the scene, just calls into question, it raises a lot more questions than answers from the alleged victim in this case. I think a probationary sentence still serves the interest of justice. And I think that this young man will benefit from that, will learn from that, and will continue to grow from that. And I think that that's what the expectation is from this court. And I think it is the expectation from any court, is that what does it look like moving forward? And I think that the fact that there has been no hiccups along the way, that I don't anticipate there being any hiccups during the course and pendency of any probationary period. And I think it's warranted in this case. I'd like to just call his mom briefly,
Okay.
if that's okay.
Sure. And she doesn't need to testify. You can just have her stand wherever.
While we wait for the mom to come up, Barbara, thank you for the $5 treats for Ellie. Ellie appreciates that. Thank you so much.
Tell me your name.
My name is Wanchella McWell.
Okay.
Good morning, Ms. McWell.
Good morning. I'm Sebastian McWell's mom.
Okay.
Okay. And just, has he lived in Georgia his whole life?
Yes, sir.
Okay.
Where was he born?
He was born here in Atlanta, Georgia.
Okay. Grady baby?
No, he's Emory.
Emory baby.
Yes.
Okay.
Tell the court a little bit about your son. What kind of son is he?
For starters, Sebastian is not a confrontational guy. I never had problems out of him. Like the last time he finished high school, went to community college for culinary art. He been on a good path. Before this incident, he was working for this tech company. He was about to convert over permanent. This incident happened. He lost his job. He had just bought his first car. So
The car that was in this situation or a different car?
This car right here.
Okay.
He bought it for himself for his birthday.
Okay. Who is Ms. Brown to him?
At the time, his girlfriend.
Okay. So she was driving his car.
Yes, sir.
Got it.
And ever since the incident happened, Your Honor, Sebastian, I think he's depressed about it because after the last time he was here, y'all stated that it was a child in the car. And that bothers him because he loves kids. And right now, like he's a helper with Amazon Flex. He's doing well. But since this incident happened, it's like he's kind of iffy by, his confidence in the working world right now. And he's not confrontation. I don't have no problem out of Sebastian. And since they put the monitor on him and everything, he's done everything the court asked him to do. No hiccups. So I just feel like he need a second chance because he's not a bad person.
Does he stay with you or does he have his own
He
place?
stays with me and I got a disabled sister.
Okay.
I work at the job that he was gonna get hired on.
Yeah.
I got hired permanent.
Okay. Well, congratulations.
Thank you. And he helped me with my sister who's
Okay.
disabled.
Sure.
Because I work a lot of hours. But like her therapy, doctor's appointment, when I can't make it, Sebastian, anybody take Sebastian will take her for me.
Okay. But he has a place to stay then in the form of the house that you and your sister occupy.
It's my home.
Your home and your sister is
She
there.
got her own home.
Okay.
So, but when her doctor's appointment and her therapy come, if I can't make it, Sebastian will go for me.
Got it. So your sister lives on her own,
Yes,
but
sir.
you help care for her, as does your son, and your son lives with you.
Yes, sir.
Got it. Okay. Well, I appreciate you being here. Thank you.
Thank you so much.
You're welcome.
Judge, I think that's all I have for the court.
Okay.
At this point.
Mr. McWell, anything you want to add?
If it was a child involved, I apologize because that really did mess with me, especially when I was sending out. And when I got out and I was on the ankle monitor, it was on me heavy. But now I'm trying to get around the curve, find employment, get over this situation and just move on with my life.
Okay. All right. You can take a seat. You don't have to stay right there.
Thank you.
Ms. Smith, in the warrant that I'm going to say it's Detective Leonce, Leonce, completed her affidavit. She says that this car that now I know is Mr. McWell's car, but that Ms. Brown was driving, was impounded for processing. I'm just curious if you have any information from the police reports. If there was a hole in the back window, it would have been there when they processed it. This seems to be a point of contention. I've seen a picture and you've seen a picture. There's a picture of a window with a hole in it. I can't tell if that's a Kia or not. I don't know that it's Mr. McWell's car. I'm not doubting Mr. Fortis, but anyone could have given him that picture and said, hey, that's the car. I'm curious what your file shows about what law enforcement learned about the state of the vehicle.
Yes, Judge. It was kind of something that was mentioned, but never followed up on. Even when the car was impounded, they didn't say much about if there was a brick found in the car or some type of hole that was in the car. When I spoke with the victim, Ms. Watkins, she did say that she never threw a brick. So that was something that she's still saying. But as far as what happened after the car was placed in the property of the agency, they didn't follow up regarding if there was a hole in the car.
Okay, if they photographed the car, those photos didn't get to you and then ultimately to Mr. Fortis.
That's correct.
Okay.
And Judge, if I can just say this, that there in the police report, there's a narrative by Officer Taylor Washington. And in that narrative, he states this is reading from the word, multiple witnesses, including Lanice Gordon, stated that during the verbal dispute between Asia Watkins and the suspects, Asia did throw a brick into the suspect's back windshield, first while trying to physically fight, and then the male suspect fired his weapon at Miss Watkins.
Okay.
So that's in the narrative.
Got it. And did you say, Ms. Smith, that one of the two, I'm not remembering the names of the two car owners, was one of them Ms. Gordon?
Yes, it was.
Okay, so that's the same person.
I'm assuming yes.
Okay, got it. All right. Well, Mr. McWell, I've already accepted your plea, so now we're just sorting out what ought to happen next. I see both sides of this. I don't understand how things spun up this much, and I'm fussing at Ms. Watkins as much as I'm fussing at you and Ms. Brown. But escalation is indeed what happened. People have attitudes when they're behind the wheel of a car, and it sounds like one of the Watkinses got out. That's escalation. And had a brick. That's escalation. Maybe threw the brick. That's escalation. And then someone brought a gun to a brick party and fired that gun. That's escalation in a way that, in my mind, is a whole lot more dangerous than throwing the brick. And I don't condone the brick throwing. I think that Ms. Watkins maybe should be charged for damage to your car and to aggravated assault. That's an assault, throwing a brick at someone. There's this notion of proportionality. Do you respond to that? You being, I'm assuming, larger and stronger than Ms. Watkins, by shoving her to the ground or making sure she stops or calling the police? Or do you pull out a gun and fire it 3 or 4 times? And in my perspective, that was disproportionate, and it further escalated in a way that could have killed a kid, could have killed Ms. Gordon, who had nothing to do with anything. She's just sitting in her car. So I don't know where people were standing and if you were aiming at Ms. Watkins or aiming at her car, but you can see what happens when someone pulls the trigger of a gun. Bullets go straight. They don't go where you want them to go. And 2 of them went straight into Ms. Gordon's car. She's still driving with one of your bullets around, stuck in the side of her car. And none of that is okay. All of that is about as dangerous as can be. The one mitigating piece, and Mr. Fortis is doing his usual good job, is that it wasn't completely nonlinear by you. It's not that Ms. Watkins said, your Kia's ugly, and you jump out and you start shooting everyone. But that she did something that damaged your car, it's a crime, endangered you or Ms. Brown. A brick going through a window is also a dangerous situation. So I get it that it wasn't just Ms. Watkins is minding her own business and you didn't like the way she cut your girlfriend off or the words she said when you guys were fussing at each other. I don't have nearly as much information as Mr. Fortis. I'm not as confident as he is that an immunity motion would have ended with a ruling in your favor and thus the extinguishment of the case. But we're here now. You are taking responsibility. I appreciate that. Here's what I'm going to do, and hear out the sentence, and then know that you still got your final plea right. So you can talk with Mr. Fortis and decide, you know what, I don't want to go to trial. I don't know what will happen then. So this is what I'm going to do. But let me ask Ms. Simpson a question. My recollection, and this was relatively new news to me and maybe to you, is that people can report to the PDC? Yeah, okay. Mr. McWell, I am sentencing you on counts 1 through 3 to 5 years. Count 4 has to be 5 years. It will run consecutive to count 1. 5 and 6 will both be 1 month. And here's how those break down. 5 and 6 are 1 month to serve. 1 through 3 are probated, and 4 is probated. So it's a total of 10 years probation. It's actually 10 years to serve 1 month with a balance on probation. But the first special condition of your probation is that you complete 180 days. That's 6 months. That's half a year at a probation detention center. The second special condition is that you have no contact with any of the Watkinses. It sounds like you didn't know them at the time, strangers to you.
I don't know these folks.
Good. Keep it that way. You don't look them up. No family member looks them up. I don't know if you and Ms. Brown are still talking. She doesn't look them up. The Watkinses need to have no contact from anyone associated with you. I will sentence you as a first offender. Your lack of criminal history justifies that. And I appreciate your mother's information that you're just trying to keep moving in the right direction. But this isn't something that you get to walk away from quite that easily. So to recap, that's 6 months at the probation detention center, but that's something that you report to when they have an opening. So you don't need to go into custody today, should you choose to go forward with a sentence. But you will be notified by your probation officer, and it's usually a couple months wait, give or take. Hey, they've got an opening, and then you report to the detention center. You do your time. You're getting credit for your probation time while you're in there, and then you are back out and hopefully moving forward with work or school or whatever it is you're going to do. I don't see straight probation as an appropriate sentence, non-custodial sentence, I should say, a non-custodial sentence as commensurate with the seriousness of what happened here, even with the provocation. I'm not ignoring anything Mr. Ford has said. I hear it, and it would be a complicated trial. I don't know what the jury would do, and you may decide that's what you want to do. So, Ms. Smith, anything from the state about that sentence?
Nothing further.
Okay. Mr. Ford, any questions about the sentence before you and Mr. McWell discuss it?
Judge, just 180 days. I think that he spent some days prior to getting a bond hearing.
He did.
Would that time, is the 180 days, is that negotiable based on either A, the time that he spent in jail before he made a bond, number one, and number two, because I know it sometimes varies from 90 to 120 to 180 days, depending on what the court orders.
Right.
And then number two, would the court take into consideration, the 6 months, not the entire 6 months, but to some of the time that he at least spent on the anchor monitor, without incident.
I've thought about all those things. I don't think the state's recommendation was off base in a vacuum. You've helped me understand that it was a more complicated situation and that there were aggravating factors on the Watkins side that helps put into context what Mr. McWell did. And so instead of 2 years, I think 6 months is appropriate. I'm aware of the 48 he did, and he gets credit for those against the month that I sentenced him for the 2 misdemeanors. So he's not going into custody today, but you understand what my sentence is. So I guess the short answer is no, it's not negotiable. That's the sentence that I intend to impose, but Mr. McWell has his final plea rights. So you and he should talk about how this is structured, the fact that he'll get to turn himself in, not go into custody today, and that it's 6 months, not 2 years, and he can decide. I'll respect his choice and your advice to him on that. And if we need to try this, then the state needs to bring the Watkinses in, and we'll learn more about what really went down. And the chips will fall where they do.
Maybe we step outside just for a
Sure,
moment.
of course.
Okie dokie, friends. I will keep an eye on that, and we'll check back in, assuming they reappear later. Good morning once again. TCF Live. My name is Dan. It's good to have you all here. If you are new to the show this morning, do take a moment and say good morning to us in the chat. We're a friendly folk here. I think you'll like us. Let's head a little further south. Say good morning to Judge Mercer.
You've been accused of violating the terms of an injunction that's entered against you. There is probable cause for that charge, Mr. Tindall. I think you're entitled to a bond as far as I can tell so far, but I've got to listen to the attorneys to see if they know anything that I'm not aware of. Mr. McDaniel, anything on behalf of Mr. Tindall?
Nothing, Your Honor. He's local. He's, I think I don't know if he's ever not appeared, but he's local here.
All right, thank you. Mr. Mitchell?
Just a few things, Your Honor. We have been in contact with law enforcement regarding some information regarding this injunction. It has been told to the state that since this injunction was enforced, I think on 4/26 or 4/27 of this year, he has consistently been in contact with the petitioner in this case. There is a hearing set for May 20th in which you're actually the one that's overseeing it. And, there's just concerns that if he gets out, it appears he's not going to follow the rules in terms of the injunction. And he even says so in the complaint where he was talking about how he was just testing the waters last night. He admitted to sending it to the petitioner and, he admitted to all this post Miranda. So we're requesting a little bit higher than normal bond when it comes to this and the obvious conditions of no contact with the victim in this case whatsoever.
Thank you. Mr. Tindall, I usually set a little higher bond for violation of injunction anyway than other misdemeanors. And the reason is the person's accused of violating a judge's order. So sometimes I think it's kind of presumptuous to think that someone's going to follow my order when they didn't follow Judge Garcia's order allegedly. So it's usually a little bit higher bond than most misdemeanors anyway, and also take into account the criminal history. Your bond's going to be $7,500 cash or surety. You have a condition of no contact with the alleged victim at all. I know that the complaint alleges she had been agreeing to contact. That's what you told law enforcement according to the complaint. Mr. Tindall, I need you to be clear. It doesn't matter if she contacts you or not, or if she agrees to talk with you. If you talk to her and there's credible evidence of it, now that there's a bond set, that starts today, even while you're still in jail. If you have contact with her and there's evidence to support that bond will be revoked and you'll have no bond at all. You'll just be there. In the meantime, you have the right to a bond. That's the bond I'm setting. It's cash or surety. You'll get to use the phone in a few minutes to try to post the bond. I'm also going to ask the jail to give you notice for your court date, and that will be June the 2nd, June the 1st. June the 1st at 9 a.m. will be your court date, Mr. Tindall. But if you do post bond, or even if you don't, you can have absolutely no contact with the person who's named in the injunction. Mr. Tindall, do you have any questions, sir?
That's it.
All right. It's just been hang on a second. Just a second, Mr. Tindall. Our clerk has a question. Mr. Tindall, we've got your first name spelled a couple different ways. What's the correct way to spell your first name, sir?
Nicholes.
ES. So the jail sheet is not correct. The complaint is correct. Sarge, if y'all can make that correction out there. Mr. Tindall, wish you the best, sir. You'll use the phone shortly. We have Rita Lynn Cobb. I'm sorry, Rhea Lynn, not Rita, Rhea. Ms. Cobb, good morning. Ms. Cobb, I saw you yesterday, first appeared you on one charge. You now have a second charge of resisting or obstructing a law enforcement officer. Ms. Cobb, I'm going to tell you there is probable cause in the complaint. This is based upon you allegedly giving a false name for a co-defendant who I'll see in just a minute. I'm appointing the public defender's office to represent you in both the charge from yesterday and the charge from today. And I'm asking that you listen to Mr. McDaniel, your attorney, ma'am.
Your Honor, in case number 26222MM, she's going to plead no contest to the two charges. Standing 4 months in the county jail, 2 days of jail credit, $370 fine. She has waived the right to jury trial and call witnesses. That'll resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
And Ms. Cobb, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
No, sir.
And is that the plea that you would like to enter, ma'am?
Yes, sir.
Ms. Cobb, I'm going to accept your plea of no contest of these two misdemeanor charges, resisting an officer without violence and petty theft, I'm going to judge you guilty, sentence you to 4 months in the Jackson County Jail, give you credit for the 2 days you've already served, impose the standard court costs and fines in the amount of $370. Is that right, Don? $370 in count 1, waive the court costs and fines in count 2. And just to clarify, it's 4 months in each case. Actually, it's not. It's 60 days is the most you can do in the petty theft. It didn't have an amount in the complaint. Remember from yesterday?
Yeah, I remember you saying
They can't be a first degree because I found no probable cause. I found probable cause only for a second degree, regardless of how they. Do you mean in the statute subsection? Yeah, so there's no probable cause for first degree. I found probable cause for second degree because I asked Mr. Mitchell to notify the officer to put the amount in there.
For purposes of today's plea, we can amend the charge to a second degree petty theft and make it easier that way.
So just to clarify, you have a 60-day sentence on that petty theft because that's the maximum for that charge. Then you have a 4-month sentence on the new charge of resisting. They're running at the same time though. So it's essentially the longer sentence is what's called the controlling sentence because that's the one that controls your release date. And that one's 4 months in jail. And I think I already said it, but I waived the court costs and fines in the second count, the resisting. So Ms. Cobb, I do wish you the best, ma'am. There's no probation involved in this sentence. When you finish this sentence, you're through with this case. Ms. Cobb, do you have any questions?
No, sir.
All right, ma'am. Wish you the best. We have Henry Shiver next. Mr. Shiver, good morning. Mr. Shiver, I also saw you yesterday, but it was not under the name Henry Shiver. It was under the name
Robert Thompson.
Robert Thompson. Mr. Shiver, so you're accused of 1 count of petty theft from yesterday under the Thompson name. You also have a new charge of resisting an officer without violence, and you have a hold out of Franklin County in case 26-670 CF. That hold out of Franklin County appears to have no bond on it. I'm appointing the public defender's office to represent you in Jackson County. There is probable cause for the 2 charges against you here. Listen to Mr. McDaniel, please, and we'll see if you have any questions in just a moment.
Your Honor, in case number 26223MM, he's going to have to plead no contest to the charges that's listed. The understanding, he'll be sentenced to 6 months in the county jail. You have 2 days jail credit, $370 fine, waive his right to a jury trial and call witnesses. That'll resolve this case today.
Thank you. Mr. Mitchell's had agreeable with the state.
It is.
Mr. Shiver, did you hear that agreement?
Yes, sir.
Mr. Shiver, any questions about that agreement?
No, sir.
Sir, is that the plea you would like to enter to resolve these 2 misdemeanor charges?
Yes, sir.
Mr. Shiver, I'm going to accept your plea of no contest to the charge of resisting an officer without violence and petty theft. Adjudicate you guilty of both offenses. Find the plea is freely and voluntarily entered with the advice of counsel. Sentence you to 6 months in the county jail on the resisting, 60 days on the petty theft, but they're concurrent. So it's essentially 1 total sentence. The controlling sentence is the longer one, which is the 6-month sentence. Court costs and fines imposed of $370 only in count 1. Waive the court costs and fines in count 2. Just like Ms. Cobb, you have no probation involved. Mr. Shiver, you finished the jail sentence. This case is over with. Mr. Shiver, do you have any questions, sir?
No, sir.
All right, Mr. Shiver, I wish you the best, sir.
Thank you.
Yes, sir. Mr. McDaniel, I know there's a case that you emailed us about yesterday that we need to talk to the jail about. That was that motion. What was that defendant's name, Mr. McDaniel?
Sandy King.
Sandy King.
State versus Sandy King. So Mr. McDaniel has made Mr. Mitchell and myself aware of a motion for early release. So what I did, gentlemen, let me get the style of the case on the record. I know Mr. King's not here. We'll bring him up. Obviously, I just wanted to talk to you about it. Case 26-22 CT. I went and watched the sentencing. So my question, Sergeant, is Mr. McDaniel is asking that Mr. King be released early for a child's high school graduation, but when he was first appeared, he had a hold for Orange County. Does he still have that hold?
That was dismissed, Your Honor.
So the Orange
Yes,
County
sir.
hold is gone. Okay. So Sergeant, according to Mr. McDaniel's motion, in Mr. King's case, his regular release date would be early June, around the 1st.
June 1st, yes, sir.
So is it safe to assume he's in the trustee program and had no problems and doing well?
Yes, sir, he is doing good.
And Mr. McDaniel, you're asking for a release date of when, sir?
I'm thinking May 22nd is fine. And I sent it to his wife last night and she emailed me back and she didn't have anything. She didn't say anything about the 22nd date. So I think that's fine. The graduation is the 23rd. So if they got out the 22nd, they just drive back to Orlando. And I think the 22nd is enough time.
Mr. Mitchell, you may remember this case. The offer was originally 60 days. Right before the pretrial, after the arraignment, before the pretrial, you changed the state's recommended offer to 6 months. Then it come time to plea, you weren't here.
Yes.
Mr. Gill covered the sentencing, and I listened to both sides. He had a job. He had a horrible driving record, but he did have a job. And according to him, he was driving a very short distance from one solar panel field to another, and I sentenced him to 4 months, and even told the jail that he could be released a couple of weeks early to go deal with the Orange County warrant. So I guess my question is, what's the state's position on Mr. McDaniel's motion for him to be released, his sentence to be amended and shall it be completed as of May 23rd so he can go to his daughter's graduation?
We have no objection to that.
Okay, I don't have a problem with that either.
May 22nd.
I'm sorry, May 22nd, but I think I may be out May 22nd.
Great. Yeah, that's why.
So let's just bring him up tomorrow. We'll go ahead and put on the record that whatever his sentence will be, it'll be considered completed as of May 22nd. That way it'll be on the record. Y'all will know. Now we'll make it subject to him staying in the trustee program, obviously. So if he does something to lose the gain time that y'all think he's going to earn, that'll change things. But Sarge, if we can add him to the list for tomorrow, since I'll be out on the 22nd, we'll go ahead and deal with it. No one else have to deal with it.
Yes, sir.
Sergeant, anything else from jail today?
No, that's everything.
Mr. McDaniel?
No, Your Honor.
And Mr. Mitchell?
Nothing for the state, Your Honor.
All right, ladies and gentlemen, that concludes first appearances. Mr. McDaniel and Mr. Mitchell, I promise y'all I would get you some information on those coverage dates. We're going to do that off of YouTube.
Okie dokie, friends, that brings to an end his day. Let's go back to Judge McBurney. That previous defendant is back.
All right, let's get back on the record in State versus Mr. McWell. Mr. Fortis, you and Mr. McWell took an understandable break to discuss. Does he want to go forward or does he want to withdraw his plea?
Judge, he would like to go forward. I did discuss the court's recommendation, or the sentence rather, and he believes it to be in his best interest. I indicated with him that I was willing to try the case. I talked to him about the same things that we talked about before, which were, some of the pros and cons of the case and the outcomes of the case. I think that this is a good outcome. And the fact that the court's allowing him to enter his plea under the first offender, I would ask for two things. Number one, I would ask the court to consider restricting his record. I can send a proposed order so that when he gets done with this, because obviously he's going to lose his job, but in retrospect, without this on his record, I think that if the court were inclined to grant my request, that I think that he would be actually more employable to would-be employers for probably a better job than he has now. And I would ask the court to consider that. And I do believe that he's entitled to a behavioral incentive date.
Okay. Mr. McWell, I will certainly, and you should send a copy to Ms. Smith. The state rarely objects, but I will certainly enter an order that restricts access to this case. Because you're being sentenced as a first offender, it's not a conviction, which means as you're thinking about going back to school or getting a job, it's not the kind of thing that ought to pop up. An employer ought not to be able to see it. But that employer could right now. But if Mr. Fortis gets me those proposed documents, then I will certainly get those in place. As for the behavioral incentive date, I already thought about that. I think first offender is the right opportunity here. And I think you, Mr. McWell, will control how quickly probation would reach out to me to say, can we just close this case down? If you are on probation the way you have been on bond, probation is very quickly going to get tired of having to supervise you because you're not presenting any challenges at all. And they can reach out, as they typically do when there's a longer term of probation, to say, can we terminate this early? But I'm not going to build in the bid. Given the fact that you're getting first offender, I think that benefit ought to carry with it the ability to monitor things a little bit longer. and certainly to give me the ability, if something doesn't go well while you're on probation, for there to be some pretty meaningful consequences. I hear your mom loud and clear, and basically your life story, that I'm hearing about your one worst moment. And I'm not painting a picture of Mr. McWell as this gun-toting, dangerous guy. Your worst moment just happened to be super dangerous, with a little kid in the car and a completely innocent bystander sitting in a car that got hit twice. That's what's yielding these consequences. It doesn't define you. And that's why I think first offender is appropriate. And that first offender is really not a risk for you. You're not someone who's going to have issues going forward. And so you'll be able to take full advantage of it. Anything else, Mr. Fortis?
No, Your Honor.
Okay. Ms. Simpson, we need to give Mr. McWell reporting instructions. Do you want to meet with him?
That'd be great.
Yeah, we'll get on the record.
His reporting date is May 7th at 10 a.m.
Okay, you live in Fulton County? Okay, so May 7th, and you'll be given a piece of paper, but that's about a week from now, 8 a.m. Don't miss that report date. And to be clear, that report date is you meeting your probation officer. You're going home that day. That's not going to the detention center. It's plugging in with probation so they can figure out, do a home visit, and connect with you, okay? All right, thank you.
Thank you, Judge. It's good to see you.
Alrighty, friends, that closes out that case. We might come back to Judge McBurney later, but let's go up to Lake County, Ohio. Judge O'Donnell.
Thank you, Your Honor. We're present today in case 26CR124, State of Ohio versus David Weinberger. The defendant's present, represented by counsel William Watson. We're present on a hearing on defendant's motion to modify a condition of his bond. The state has filed a motion in opposition to that. Thank you.
Mr. Watson. Thank you, Your Honor. May it please the court. During my client's preliminary hearing, I believe out of Willoughby Municipal Court, he was granted a bond along with some conditions, including having a SCRAM bracelet. My client does currently have that on. There is a cost involved with that SCRAM bracelet. I believe it is roughly $400 a month. My client is a senior citizen, lives on a fixed income, Social Security. He simply can't afford it. I've talked to him several times. You know, he's staying at home. He's not drinking. He's not driving, most importantly. In fact, he got a ride here this morning, and he apologizes for being a little late. They got apparently a little lost. But Your Honor, he simply can't afford the $400 a month. You know, I can appreciate the state's position of wanting him to not drink and drive. I'm not trying to undermine the seriousness of the charges here in this case, but the fact of the matter is, if he were a wealthy individual, then he could stay at home, and if he's not, which he isn't, then apparently the state wants him to sit in jail. And I'm simply asking the court to consider removing the SCRAM bracelet. If the court wants to add any other conditions of bond, we're certainly more than welcome to it. And I apologize, Your Honor, for having my phone out. The court had brought this up in chambers, but just to let the court know, I was looking at this before Your Honor came in. The first email from Ohio AMS about the non-payment was dated March 16th to Craig Berry. As far as the non-payment goes, though, it wasn't brought to my attention until April 14th of this year, so approximately 2 weeks ago, about a month after the first email. And I believe at this point, Mr. Weinberger is at least 2 months behind, according to Ohio AMS. I'm respectfully asking the court to, take a look at my client. Feel free to ask some questions, but he can't afford it. And in order to prepare for his defense, I'd respectfully ask the court to allow him to stay out on bond. Thank you, Your Honor. Mr. Tuttle.
Thank you, Your Honor. The state does oppose the defendant's request to remove that SCRAM monitor due to the serious nature and alcohol-related nature of this offense. The defendant was the driver of a motor vehicle that was involved in a head-on collision that caused serious physical harm to the driver of that other vehicle. He's required at least one surgery for an injury to his wrist caused by the defendant. At the time that crash occurred, the defendant's blood alcohol was at 0.139 grams per 100 milliliters. There was also THC found in his blood at the hospital. He did consent to that blood draw. There is a long history of alcoholism, it seems, as reported by the defendant's family, the defendant's passenger in his motor vehicle, as well as his hospital records. The defendant had open containers of alcohol in his vehicle at the time that this crash had occurred. So, keeping those factors in mind, we would request that the SCRAM monitor stay in place. It is an appropriate condition of bond. It is the only way that we can assure that there is not another instance of drinking.
Well, not really, because he could theoretically start drinking, get in his car and drive. Does the SCRAM prevent the car from starting?
It doesn't, but it would give us a notification if there was alcohol detected in his
Okay,
system.
and then what happens?
And
Then AMS gets a notification. Where's AMS located?
I believe somewhere in Lake County, but I'm not
So
positive.
they then notify who? Probation?
Adult probation.
And by that time, Mr. Weinberger theoretically is driving all over Lake County by the time probation catches him. So it doesn't solve that problem. What it does is causes another problem that if Mr. Weinberger or substitute any other name represented by the public defender or appointed counsel can't afford it, then they should be in jail because they're not meeting the condition of bond, right? If that's a condition of bond and they're not paying, then the answer from your side of the table is to put them in jail until the case is concluded.
That would be the only way to assure that there's not alcohol.
Well, it's not, because we just went through a scenario where he can use alcohol, get in the car and drive, and 8 hours later, that word gets to whoever, and Mr. Weinberger is grabbed up, okay? So that doesn't solve the problem. What it does is subject people like him and those who have appointed counsel, at least a great percentage of them, from being able to be out on bond because they can't pay the $400 to AMS for a SCRAM unit. Okay, so I'm going to remove the SCRAM unit as a condition of bond. Your bond is at OR still. No drugs or alcohol, no driving. You're not to reside in any residence where there is alcohol present, and you are subject to random chemical testing. If probation contacts you and says, get to probation now, and subject yourself to a chemical test, then you're to do that. If you don't do that, then you're in violation of bond, and then I will put you in jail. Any questions?
Not at all.
Anything else, Ms. Tuttle?
Your Honor, would you like us to prepare the order?
Please. Mr. Watson.
Nothing further, Your Honor.
All right, thank you.
Thank you, Your Honor.
All rise.
Fairly short hearing with Judge O'Donnell. No doubt we'll check in there later, but let's go down to Texas, Judge Stevens.
T-shirt, that's what you got. That's what you've got, a T-shirt. So you're looking at a total of 30 years in prison. Right? And you think your life's future, you know, like that's your best foot forward, a T-shirt? Look around everybody else. Look around. You see ties? The guys have ties on them. Because it's a place of importance, respect, the Constitution, important things. They may not be important to you, but they're important to most people, and they're supposed to be important for everybody. Maybe that's why you're here. The rules aren't important, but you're going to be held accountable because people do think they're important. It's the way we live together peacefully, so we can all enjoy the blessings of liberty. All right. What is the issue today?
Pat, you just pulled the second piece of paper you have in there, Judge. So highlighted area.
All right. Did you get a copy of this?
I did, Judge, and I have it in front of me.
All right. Well, it looks like last month a drug patch was collected and showed positive for cocaine as a result of the testing. Okay. Anybody wants to say anything?
Yes, Your Honor. So my client just recently was released on bond. And while he's in the,
When?
I don't remember the exact date.
Let's find the date. Okay, whatever that is. Anybody know?
I'll look up this.
But while he was in.
Let's find the date
Yes, sir.
so we can go off some things that are certain.
It was a recent bond. All that show was from 2024.
No.
He was released February 27th to 26th.
A little over a month.
Okay, I see it now.
Yeah.
Okay, go on.
Thank you. So while he was incarcerated, Your Honor, he was on some medication. And then when
Okay.
no,
They had him on cocaine?
no,
Okay.
but it wasn't a medication for mental health. And when he was released, that he didn't realize it was showing up on his drug patch until I notified him. When I was notified
What
by the
was
court,
showing? The
that
cocaine?
anything was showing up in his system.
Well, I mean, how's that supposed to be until something is collected and then tested and analyzed and then reports back to us?
Understood. But since then, Your Honor, his drug patch numbers have gone down. The last drug patch showed clean. And immediately when I notified him of the drug patch results, he went on his own and had a UA and a hair follicle, which he does have with him today, that both showed he was clean. So he did do the best he could to show.
What was the date of that?
I'm blind, Your Honor. Give me a
That's
second.
okay.
Which one is the hair? Here's the hair follicle right here. It was collected on April 17th and the report was issued on April 24th of 2026. Would you like to see it?
No. Your word's good enough for me. But on this collection on March 13th, he had been released from jail.
He had. The same week he did go take a drug test for employment and passed with flying colors. Which is also one of the documents in here. This would be the drug test he took for employment during the time of the patch.
And he had been released from jail when?
February 26th or 27th?
27th, February 27th.
Of 26.
Okay. So how do you explain the positive in March?
He believes it had to do with something that was in the medication he was taking at the jail. There is a log of the medication as well.
That's what he believes
That's
from
what he
his
believes.
medical experience
Yeah,
and
Your Honor.
medical training.
Yes, Your Honor.
Anything from the state?
No, Your Honor, I don't know what medications he's taking and hadn't had a chance to even look and see if anything like that has any false positives.
Here's a list. I don't know if any of that rings a bell for you right away, but that's what he was issued in the jail.
I don't know anything that does test positive as cocaine metabolites, but sure I'll discontinue.
Here's the problem with all of this is that nobody's given me anything about what he's supposed to be taking, but what he is taking and why. But the fact of the matter is that he tests positive for cocaine. So far, what I've heard, all I've done is open a door for everyone to come out of jail and test positive and say, I want the old Demond Sargent rule. I may or may not have been given medication. But the point is if I test positive, I'm going to use his rule and presume that it had to be something that the jail gave me, which I don't know and I can't answer to because I don't know what they gave me.
Well, he
The
did,
problem is that it tests positive. He's going to be held accountable. I can always, he's going to be held accountable. His bond is going to get revoked on this. It's just the way it is. If you want to get some more information, I'll open this door up for another hearing from experts, anybody you want from the jail to revisit this. But unless something else happens, this is the way I'm going to rule. I'm not going to presume that the jail is giving them cocaine so that they can test positive a few weeks afterwards and then claim it's the jail's fault, not mine. Period.
Let's say ibuprofen and says, I looked it all over.
apparently
What's his bonds in each case, please?
Judge, on the ag assault is $110,000, and on the harassment, it's $40,000.
Okay. You test positive for a controlled substance, cocaine, that's a second-degree felony.
My hair fall.
And your bonds are doubled.
his hair follicle did come back clean.
Let's see, 90 days.
When?
Just April.
A month later, ma'am. Not when this test was taken, a month before.
He did have some employment tests that came back clean the week it was taken. The patch was taken.
I trust these people. That's who we use. People who are, I can hear something, please leave the room. When you disturb this court, leave the room. Tindall. I'm gonna have, yeah. We're doing business here. This isn't a cry fest.
Other way.
Hey, ma'am.
Other way, ma'am.
Ma'am, your outburst just made you in contempt of court, ma'am. You can be placed in jail for up to 6 months. Would you please just be polite? Thank you. That's all we ask of people. Be polite. We're taking care of serious business up here. People don't like what happens, and so they make an outburst. You can everybody know that's the rule. You can be held in contempt of court if you make an outburst and disrupt the proceedings. Please don't do that. I don't want to put people in jail unless they're necessary. I made my ruling, so you had cocaine in your system. It's a scientific test, and the court does not believe the explanations y'all have given. So I'm presuming the test is correct. Your bonds are revoked. You're in jail, and you must have a drug patch if you post your bond. Period. End of ball game. What's next? We set this for trial or what?
Yes, Your Honor.
Is that what we want to do on these?
Well, I haven't had a chance to speak with counsel today on that.
Yeah, how about an announcement in what, 2 or 3 weeks?
That would be appropriate for you.
Because maybe something could get disposed of to move him along, get him back on his feet.
He is working for Rice.
Well, of course, he'd have to, because of this, I mean, we'd have to test him to make sure that he's negative. If something is fashioned to where he would be released.
Yes.
But he's got to pass our drug test to get released. What is his criminal history?
He has no history.
You have no criminal history? Sir?
Just a minute.
No, I'm talking about felonies.
No felonies.
Just to be clear, Judge just muted himself. That's not on us. We're a couple minutes in the way back machine and try to bump forward.
Hello. Nice throw.
Morning.
25 CR 863 is now called the State of Texas versus Lorenzo Walker. You're charged with the second-degree felony of aggravated assault causing serious bodily injury, which carries with it up to 20 years in prison. What is this announcement? Oh, okay. What are we doing today?
Mr. Ma'am, if we could get one more reset, leave there That's at my request, Judge. I'd like to visit with the victim before I make a final offer on that.
Is 4 weeks good?
Yes, sir.
Okay.
Yes, sir, please. Thank you, Judge.
Rayburn Hebert?
Right.
Just get a resetting from that lady. Yes, sir.
Harassment.
One case?
Yes.
Yes, Judge.
25, CO 499. Rayburn James Hebert.
Yes.
And you reveal Mr. Collins, your attorney,
Yes,
and the state's attorney, state jail felony, publishing or threatening to publish intimate visual matter. That's a state jail felony. If convicted, you're facing up to 2 years in the state jail, not a local county jail, but the state jail, which is like a penal facility. What are we doing today?
Your Honor, we are working toward a resolution with the court. Give us 6 weeks, please.
Okay. 6 weeks. You got it, buddy. Thank you. State, you were sure talkative during that. Did you want to add it?
He said what we needed to say.
Okay, I didn't
Thank
get
you.
a little wordy. Darren Peace, is it? Okay. Actually, it's on the docket, but I don't have the file, so that means somebody pulled the file, so.
No, I sent notification yesterday.
David Medina, Charlie. Hey, Ryan, could you please read more quietly?
Just generally.
Just, could you be more quiet?
I get a half.
Tom saying that you were interrupting him over and over when you're with your loud thinking.
Too talkative. Too thought-provoking.
You've got that scholarly appearance right now. About that.
Thank you.
I didn't even recognize you. Okay, this is 24 CR 1338, the state of Texas versus David Medina. Correct, sir? You're Mr. Medina. Mr. Rojas is here representing you. Earlier in this case, you pleaded guilty to collision involving serious bodily injury or death, which was a third-degree felony, which carried with it up to 10 years in prison. An agreement had been reached when you entered. And has he entered his plea yet?
We have, Judge.
Yes, sir.
Because it's not showing that
Back on March
on the
19th.
file. I don't even have anything on it here. What was the date?
March 19th.
Yes.
A pre-sentence report has been prepared and the parties had an opportunity to review it.
We have here.
And are there any corrections or changes to this?
Not from the state.
No.
No, Judge.
You believe me?
I believe it's about the partnership.
Then it's made a part of the record for all purposes. Has there been a determination of restitution? How much?
No, sir, I don't have anything, any correspondence. If I was looking on the computer, see if there's something that came in that I didn't know about.
Judge, my client tells me that his insurance has settled with Mr. Jones on whatever portion they're responsible for. I don't know if those policy limits or not. There may be some amount above that.
Is the complainant here by any chance? The victim? No. Okay. Where to begin? The circumstances here are disturbing that in February at approx 2024, which would have been 2 years ago, a little over 2 years ago at about 7:30 p.m., 7:13 p.m. So that would have to be dark.
Yes, sir.
If not dusk. It certainly was dark. And Beaumont police went to College Avenue F. I guess that's College and Avenue F, an intersection there in Beaumont, investigating a collision between a vehicle and a cyclist. And a witness had been following the vehicle involved in this. I guess that's the defendant's vehicle, Ford F-150. And they officers subsequently located, detained the driver, who was the defendant, Mr. David Medina. And he confessed to hitting what he thought was a bicycle, panicking and fleeing to his home without providing assistance. Investigation later showed that the cyclist suffered multiple fractures, significant laceration, and was arrested and then ultimately charged with this third-degree felony of a collision involving serious bodily injury or death. And as far as the injury was concerned to the cyclist, he sustained severe injuries requiring approximately 8 months of hospitalization in 2024 across in three separate medical facilities, undergoing a surgical procedure in which part of his skull was removed, as well as the insertion of approximately 25 pieces of metal into his hip. Due to the severity of his injuries, he's no longer able to return to his prior employment as a carpenter and is now significantly limited in his ability to earn an income. He is currently trying to work for Uber Eats, but is unable to achieve comparable earnings to his previous employment when he was not injured. And that he has an ongoing financial hardship that has resulted in his current residence in a homeless shelter of all things. Let's just get sadder and sadder the more you read. All right. What to do? The agreement here is whatever sentence shall not exceed a cap of 8 years imprisonment. So you were looking at no less than 2, no more than 8 years confinement in prison. Can I give him regular probation?
Yes, sir. This is not a one you do the deadly weapon finding on because
there was a vehicle is in its use and it caused serious bodily injury. It means it fits a deadly weapon. So we're not foreclosed.
You're not, because it's not, you cannot make a finding of a deadly weapon on a failure to render aid.
Then there could be deferred or unadjudicated probation.
Yes, sir.
Is that what you see, Charlie?
Yeah.
Thanks. All right. Go ahead, State.
Judge, looking at the victim saying 8-year sentence is not enough, well, the most we can give him is 10, and giving him credit for taking responsibility is at least now and pleading guilty and confessing to it at the scene. I thought the 8-year cap was appropriate. That I still think the 8-year sentence is appropriate in this because just leaving somebody there with those injuries, he could have died and it could have been a 2nd-degree felony. Then we would have been looking at something else, possibly manslaughter charges, things of that nature. But because of the way the grand jury indicted it and looking at the seriousness of the injuries, 8-year sentence is pretty light, but it is within the upper range of the actual offense charged. I just can't imagine leaving somebody there on the side of the road, no matter how much you fear the cops. It's just your instinct is to just stop and help somebody when they're hit, and he just took off. So we would ask for 8-year prison sentence.
Go ahead.
Judge, certainly his injuries, Mr. Jones' injuries are severe. Mr. Medina made a terrible decision to leave the scene. I don't think anybody can argue with that. If you look at Mr. Medina's statement, he panicked and went home, and his intentions were to call the police. It's just the police got there before he could make that phone call. We're asking the court to consider probation. He has accepted responsibility, once the police got there, he didn't deny that it was him that was driving the car. He readily accepted it was him. He's coming to court and pled guilty to it, Judge. Mr. Jones is asking for restitution. As I say, Mr. Medina's insurance is paid. I don't know. I don't have the information in front of me. I would believe policy limit's about $30,000. Certainly his bills are more than that, to be in the hospital for 8 months. Mr. Medina is working. He's always had a job. He's working construction now. He would be in a position to make payments towards restitution. The court could order that payments go first to restitution, then if they were to put him on probation, to try to make some restitution to Mr. Jones, so that we can hopefully have given a little bit better life than he's got right now, which he certainly deserves after going through this. Mr. Medina has a limited criminal history. He's got one case where he was on probation for marijuana, a deferred adjudication. Looks like he successfully completed that. As far as I think that's the only adjudication that he's got in the pre-sentence investigation. He has a support system. Both parents are available to him. He has a sister that lives here in Beaumont, and it appears that they get together regularly. They are able to support him in any way possible. We're asking for a chance on probation, Judge. I looked at the PSI. It looks like they're recommending that if you were to give him probation, save P. And if that's something the court wants to do, obviously we can't complain about that. He just is asking for a chance to continue his life, make restitution payments to Mr. Jones.
How much is the restitution?
I don't have anything.
There's no amount.
Mr. Jones.
It's that's something probation can determine at some point.
I think the victim in this case wishes restitution, but there's nothing based, that I have a basis to order, except to order restitution in an amount to be determined, I guess. But
And it doesn't look like, I think if probation is to determine restitution, I don't think they have a problem getting in touch with Mr. Jones. He gave a pretty detailed statement.
I'm going to ask that no matter what happens, restitution is going to be ordered in an amount to be determined. But all the parties agree that restitution is owed here, and it is going to be ordered in some amount, but I can't just say a number now because there isn't anything here that causes me to be certain, and I want to be accurate, and the victim needs to be heard into as to how much he's going to he needs to receive in his losses, based upon his losses. But anything else?
No, Judge, but I think Mr. Medina would like to make a brief statement.
Go ahead, sir.
Yes, sir. I understand that I did wrong.
What did you do wrong?
Leaving that man.
Why did you do that?
I sat scared.
So you knew somebody had been injured, somebody is laying on the ground, and you just drove off?
That's correct.
Sir?
That's correct.
I'm glad somebody didn't run over him after he had been injured. He's just laying on the road for others to clean up the mess that you had caused. That's so inhumane.
I understand.
Okay.
I wish I would have done things different.
Well, but the police arrested you later that day? How long after the event?
Even maybe an hour.
Half an hour. But up until that time, you weren't about to turn yourself in, right?
I wouldn't. Yes, sir.
You didn't. Apparently 30 minutes with somebody knowing someone was laying on the ground that you had caused injuries to, that, and for a half an hour, that didn't bother you to call the police and say, it's me. What do I need to do? They had to come get you, right? Yes. Okay. It's a bad thing altogether. All right. Anything else?
No.
Here's what the court's going to do. We have a multi-level set of circumstances here. This is like a bar exam. Because there's different dynamics involved in this one. I'm going to find that you, Mr. Medina, have pleaded guilty to this third-degree felony of collision involving serious bodily injury or death. Guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony. Now, the agreement is whatever sentence shall not exceed a cap of 8 years confinement, which puts the court in a position of 3 different options: deferred or unadjudicated probation, which is foreclosed now because I have found you guilty of this felony beyond a reasonable doubt. We have regular probation up to 10 years in length and confinement in prison. The state is asking for confinement, and your attorney is asking for probation. The state's request is certainly reasonable.
It's also based upon what the victim wants to, Judge. Complaining in the case.
Here's what, and I've seen this, the victim has all, between his physical problems and his monetary loss, he is in a bad situation. Here's what the court is going to do. I am going to sentence you to 8 years in prison. Everybody listen and hear me out. That will be suspended. You were placed on regular probation for 10 years. Number one, as a condition of probation, I can place you in a jail for 180 days. I'm going to do that. You're going to have to do 6 months in jail. After that, you are going to go directly to a substance abuse felony punishment facility and complete a substance abuse program. You will also be ordered to pay restitution to this man, and it'll be whatever his full losses are that are still that we all the parties agree are necessary, but are not determined at this time. Your statements here in this pre-sentence report about your let's see, marijuana use, which is overwhelming for years, daily, from the age of 15 to December 2025. How old are you now?
32.
32. 17 years of marijuana. Cocaine from 28 to December of 25, frequency on weekends. You're also going to do this. You're going to be ordered to fully cooperate with law enforcement on the sources of these drugs that you have acquired. And you're going to take a polygraph test. And if I catch you lying, that'll be another reason that could be used where your probation could be revoked. The state's request is certainly reasonable, but you need some other help as well as confinement. And you're not going to get it by going to prison. And the poor victim here needs his value and his expenses paid, which are going to be thousands of dollars, which you're going to be responsible for, which you would not be if you go to prison. But you're going to be in a facility, a prison-like facility, for at least 9 months, which is maybe less than what you deserve from what the victim's problems are. You've made a big mess here, but the biggest mess is your decision to use drugs illegally. And every one of those instances is a crime in itself. So every one of those. And you're doing it for years. You've been doing it for years. But between cooperating with law enforcement as a condition of your probation, going to confinement in jail for 180 days, which is the most I can order, and going from there directly to substance abuse. I don't want his feet touching the ground until all of this is accomplished, and you cooperate with law enforcement and they send something back to me that you have been that they're satisfied that you cooperated. Those are going to be included with the conditions of the other conditions of probation that we normally assess.
Do you have orders, Judge, that probation's asking if you have a set of orders underneath your file? Is this underneath your file here? Is this?
Oh, I'm sorry. I know. I didn't. Over here. They always send it to me. Here's some special, you have special conditions as well. This is the substance abuse felony punishment facility special condition. I'm signing on this day.
Oh, you're good, but we want to. Anytime I'm not sounds you're good. It's so bad. I want them all. Yeah. $1,000. This was.
There's no fine because the restitution is going to be,
Thank you, Judge.
is going to be, I'm putting TBD, to be determined.
Yes, sir.
Okay, also 180 days.
Yes, sir.
And when do we begin this? You report in Friday,
Right.
on or before 6 o'clock PM. You understand, sir? It'd be. Is it,
coming Friday? May first.
there's 31 days in April, right?
30.
Yes,
30.
30
in April.
Yeah, okay, tomorrow's Friday. Okay, got it. So you want to check all of this, because
Yes,
that's all I'm saying.
And once you sign all those orders and they get sent over to the jail, that safety hold will be placed on him anyway.
Yes,
So once
sir.
he completes that 180 days, he'll have that hold, so he won't be able to step foot off the ground. Yes, sir.
Thank you.
Yes, sir.
Explain. That's. Anything else?
No, Judge.
That is all. You're in recess on this.
See fingerprints.
You guys let me know what you think in the chat, but that sentence works for me. I mean, the guy had a whole ton of injuries and stuff, but he's going to need restitution. And if you put him away for 8 years, then there's no chance of him seeing a dime. At least now he's got a chance. So I think that works. If you see it different, let me know. Let's go back up to Michigan. Judge McNally just got his day started a few minutes ago, so late start for him, but let's see what's going on.
Your name?
Officer.
Mr. Reynolds, you gotta slow down, sir.
Absolutely.
If you see mine hat, please. If you see mine, you have to, my name on it next time. You just know that I'm not gonna give you impeding, okay?
Okay.
All right, to the charge of impeding traffic, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the limited access. Fines cost 180. You can go down the hall and take care of that. You're all set. Thank you. I'm gonna take that misdemeanor now, if you guys can get it to me. Faith Aloma Oni, 26R 514-621. Your name?
Faith Aloma Oni, sir.
Good morning, ma'am. You're gonna plead to impeding traffic, correct? All right, to that charge, you plead responsible or not responsible?
Responsible.
All right, you got a clean record. I'll accept the plea, dismiss the speed, 150, you're all set. Cashier into the hall, you're right. Good luck. Give me that file, guys. Come on, I need your help today. Where's that file at?
He's having a problem signing judges. Right.
Crane, Brian Charles Crane, 26F 265-605. John, give that file to Mr. Pellin when you get it back on Earth Day. Good morning, counsel. Your appearance?
Good morning, Your Honor. My name is Edward Paul. I'm at HL 27115 Studying.
Sir, your name?
Brian Crank.
All right, so your client's charged with malicious use of a communications device. How is he going to proceed?
Your Honor, we are waiving the reading of the charges and we are submitting it.
All right, I'm entering a not guilty plea. I'm going to set a bond. All right.
He's been employed at post office for 25 years. He has a pretty clean record.
Okay, well, I'll give him a personal bond. I don't have a problem with that, but I'm telling you, no contact with her. If I find out you had any contact with her or go near her, then I want you to understand, I'm going to go ahead and set a bond you're not going to be able to make, okay? So no contact at all with the victim in this case. You cannot write, phone, see, text, email, or communicate in any way with Susan Sherbrooke. No contact, direct or indirect, either you direct or through another person. No contact with prosecution witnesses. You're not to enter or go near 25801 Valley Creek Drive, apartment 1001 in the city of Flat Rock. You're not to leave the state without consent. You're not to violate a law. You must appear in court as directed. You cannot possess firearms or dangerous weapons. And you have to go over to the Flat Rock Police Department to get fingerprinted and photographed today. And you have to do that by noon, okay? So you'll leave here. We're going to give you your notice, and then you'll go over there. You'll get printed, photographed. We'll send a copy of the order over, and we'll go from there. Any questions? Mr. Mall, anything else? Nice to see you, Mr. Mall. All right, go down the, oh, wait, have to give you a date. I'm sorry. What do you have, Heather?
We can do May 7th at 9:45.
Good with you, Mr. Ball?
Yes, Your Honor. That's for a pre-trial.
Right, May 7th at 9:45. Okay? Best of luck to you. Thank you.
I'm sorry, what was the bond you were doing for him?
I thought let me see, 1,000, I think I said.
You did say in the bond before.
Yeah, 1,000 personal. 1,000 personal. Okay? John Freddie Arango Canones, 26F 245-835 A, B, and C. All right, Ms. Villarreal, you're still under oath. Okay. Sir, your name?
Señor, díganos su nombre. John Freddie Arango Canones.
Mr. Mays?
Good morning, nice to hear from you.
Yeah, I mean, jeez. All right, so he stood mute, waived formal reading.
Yeah.
Now there's going to be a plea of guilt to the charge of operating while visibly impaired with the driving while unlicensed, operating while intoxicated, and avoiding traffic control device, all to be dismissed, correct?
Correct.
Is that what you want to do, sir?
¿Y eso es para lo que usted quiere hacer, señor?
Judge, it's an comments.
Why, was there an accident?
No, Judge, it's a lack of recollection.
Do you remember what happened when you were driving, sir?
¿Recuerda usted lo que sucedió cuando usted estaba manejando, señor? No contest.
No, I didn't ask you that. I'm asking, do you remember what happened?
No le estoy preguntando esto. Le estoy preguntando si usted recuerda lo que sucedió.
Judge, the
Well, the
recollection,
police officer stopped me.
he doesn't recall what he drank and how much he drank. He also doesn't recall what happened directly after.
All right, but you remember driving, right?
Pero usted recuerda haber estado manejando, ¿verdad? Yes.
All right, I'm gonna take a guilty plea. Yeah, if you plead guilty to operating while impaired, the possible penalties are up to $300 in fines, 93 days jail, 360 hours community service, court costs or all those. 4 points would be added to your traffic record. Your license would be suspended or revoked in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand all that?
Yes.
All right. Did Ms. Villarreal read the advice of rights form to you?
La señora Villarreal le dio usted el aviso de derechos. Yes.
If you plead guilty, you're giving up all of those rights and we're not going to have a trial of any kind. Do you understand that?
Usted está renunciando a todos estos derechos y no va a tener un juicio de ningún tipo. ¿Comprende usted eso? Yes.
Do you still wish to plead guilty?
¿Y usted aún quiere considerar declararse culpable? No contest.
I'm not taking a no contest plea, tell him.
He's explained to him, he's not taking no contest, it's gotta be a guilty.
Yes, guilty.
I'm going to ask you again. To the charge of operating while impaired, how do you plead?
Y vuelvo a preguntar usted. Hacía el cargo de usted está manejando su habilidad en general. ¿Cómo se declara usted? Yes, yes, guilty.
Were you operating a motor vehicle in the city of Flat Rock,
Y usted manejando mi vehículo estaba en la ciudad de Flat Rock
on Telegraph,
y la calle de Telegraph.
near East Huron River Drive,
I'm sorry.
near East Huron River Drive, on March 30 of 26
De marzo del 2026
at 12:44 in the morning.
a las 12:44 en la madrugada.
Prior to that, did you consume alcohol?
Y antes de haber hecho eso, he consumido alcohol. Yes.
What kind of alcohol were you drinking?
¿Y qué tipo de alcohol está usted tomando? Beer, Corona, that's it.
Okay. Did you have more than 8 of those?
¿Se tomó más de 8 cervezas? I don't remember.
Okay, but do you remember drinking,
It took me a half hour.
do you remember drinking several Coronas?
¿Recuerda usted haber tomado varias botellas de Corona? Well, I was drinking for a half hour. I don't know how many I consumed.
Okay. Why were you pulled over by the police?
¿Qué no conoce la policía? Because the traffic light is different and I'm.
Okay. And were you ultimately arrested and transported to the hospital?
Y al fin y al cabo usted fue arrestado y fue transportado al hospital? No. No, first to the police station.
I know, but ultimately, did you go to the hospital for a blood test?
Sí, pero al fin y al cabo usted lo llevaron al hospital para que hicieran una prueba de sangre. After about 5 hours, maybe 4.
All right. And counsel, do you stipulate that the blood draw was accurate for purposes of the plea with the result of 0.195?
Yes, sir.
They had also already given me some water to drink.
Are you on probation or parole?
Before they took me to the hospital, they gave me water to drink.
Are you on probation or parole?
En este momento, ¿está usted bajo libertad condicional o libertad probatoria en alguna edad? No.
Do you understand that there could be immigration consequences associated with this?
Y comprende usted que pueden haber consecuencias inmigratorias asociadas con esta declaración. Yes, and in case I ask you to forgive me because I made this mistake.
Do you still wish to plead guilty?
¿Usted aún quiere proceder a declararse culpable? Do I tell them yes?
Is he asking for it?
I'm asking you, do you want to still plead guilty?
Tanto a usted, usted aún quiere proceder a declararse culpable.
That'd be far. Judge, I explained the immigration consequences then. So I will ask him to give the answer to my question. Sir, when we were reviewing the file, did I review the potential immigration consequences of a guilty plea with you?
Señor, cuando estábamos nosotros revisando este expediente, ¿no le explico yo a usted las posibles consecuencias inmigratorias? Yes,
And
yes, sir.
at that time, you were made aware that there could possibly be issues with regard to your status based on pleading guilty to this charge.
Y en ese momento calculó usted que quizás iban a haber problemas debido a su estatus inmigratorio y este tipo de datos.
And
Yes,
can I
sir.
answer all your questions with regard to any concerns you may have in pleading guilty plea?
Y no le contesté yo todas sus preguntas acerca de qué le preocupaba a usted se tomaba una declaración de culpable. Yes.
And you will agree to the plea offer, knowing well what the possible immigration consequences would be, correct?
Y usted estaba de acuerdo a esta declaración de culpable reconociendo cuáles las posibles consecuencias con inmigración pudieran haber sido, ¿correcto? Yes, sir.
All right. I'm going to accept your guilty plea. I find it to be an accurate plea. I'm going to dismiss the OWI, dismiss the disobeyed traffic signal, and dismiss the driving while unlicensed charges. I'm going to refer you for a screening and assessment. You're going to fill out a questionnaire and be interviewed today. Probation will prepare a report and recommendation. You will have a chance to review that with your lawyer when you come back for sentencing. Okay? Do you have any questions?
¿Alguna pregunta? No.
Judge, I do want to.
I have to address bond too. Go ahead.
Mr. The defendant here did pay the C charge, Judge. He paid $135, but that was ultimately dismissed. Would the court be able to?
Yeah, he's paid that, Heather?
You showed me he did pay $135.
Yes, it looks like he did, Judge. I'm double checking that right now. Yes, he did.
I'm dismissing that, and that $135 will apply. Put that as a bond.
Okay.
I will make the bond on this case, on the drunk driving, $135 cash. So you're going to transfer that money over to the A file.
Okay.
Here are your bond conditions, sir. I'm going to give you a $135 cash bond. We'll apply the money that you paid to this case. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No alcohol. You're not to purchase, possess, or consume alcohol. You're not to purchase, possess, or consume marijuana or illegal drugs. You're not to have any contact with prosecution witnesses.
No, I have never done drugs.
You cannot have any contact with prosecution witnesses. You have to go to AANA at least one time per week. My court officer is going to hand you a form. Probation will tell you where a Spanish-speaking AA group may be. You also have to go over and get fingerprinted and photographed at the Flat Rock Police Department by today at 1 p.m. I'm filling out an order, and you have to go over there today. We are going to give you a sentencing date. The sentencing date in this case will take place on
What is that? That phone's gotta be out of the building. You gotta take it out of the building. $5 a door.
Go ahead. What do you have, Heather?
May 7th at 8:30.
May 7th at 8:30.
Right here.
Correct. You're going to be screened and assessed today, like I said. So you're going to go down the hall, get your paper notice. Then you're going back to probation where you'll be interviewed. Ms. Villarreal will be with you. And then you'll come back on May 7th. We're going to give you an AA verification form. Every time you go to AA, you have to bring that form with you and you have to have it signed. Every time you come to court, you have to bring that form with you.
Okay.
Do you understand all of that?
Usted ha comprendido todo esto. Yes.
All right, good enough. You're all set. I wish you well. Good luck. Any questions at all?
This condition's not gonna affect his being able to get fingerprints.
But he's gonna have to go over and try. I'm sure they can do it with the left hand. I don't know. That's a good question.
Cut off.
What's that?
He's completely severed his two fingers.
Ugh. That's not good. All right, go over there and if you can't, I'm sure they're gonna print him with his left hand. All right? Good luck, sir. Thank you.
Alrighty, friends, TCF Live. 20 or so minutes into hour 3 already. Time flies. Let's go down to Texas. Judge Boyd.
On this appeal day, Judge, the reapproach on that, he's scheduled for May 15th for the mental health court. I think this court date was a status to see about his entrance into that program.
Okay, I already reset that.
It was to May 7th.
Yeah, do you want it on a different day?
Would it be possible, Judge, for you guys to reset it to the May 15th, the mental health court date?
What's the cause number, do you know? Well, you know what, his name is,
It's on there.
oh, just 1 second. Okay, 2025.
CR
Mhm.
006971.
We were just looking to see about on the same dates because he rides the bus. He's out currently at Cross Point, so for just to come two times in 2 weeks, it might be a little bit difficult. But he advised me he's meeting with Crystal and abiding by the terms of the program and looking forward to be successful in the program.
Awesome, how are you doing?
I have a word to tell you.
Yeah.
If you allow that.
Yes.
Of course.
I know I have a word, and I know I look very bad, but I want to come back to the good one. When I was 11, I broke my private part, and it filled 4 years ago.
Let me just tell you this.
Maturing at an old age. So when I was at a bus stop.
So let me just tell you right now, number one, you don't look bad. You're looking great today, okay? So I always tell people, wherever you start in life, that's your starting point. It's not supposed to be your ending spot.
Just started learning.
Yeah.
Instead of learning that, you know,
Yeah.
I have this 10-year-old break.
Yeah. So this is the thing about the program you're going to enter into. We're all going to want to help you. That's how the treatment programs are supposed to be. So the thing is, you got to reach out for the help. If you see yourself struggling, don't think you have to struggle alone because we're all there to help you and we want you to be successful, okay?
I would appreciate any kind of good words towards the rehab.
Mhm.
So I can have a better life. 'Cause I got school. It was done at a young age. I became hurt. And I healed 4 years ago. Was recovered. So I need to step my life up and be an adult now. Make good despite godly moves in life. I want to go to school. So I've been in school for a month and a half.
Oh, awesome. What are you taking?
Right now reading, I'm about to take my finals reading 70.
Okay.
So I just got, you know, they want to.
Yes. So here's the thing.
Sorry.
You're doing
Get it
great.
done. I just would do it later on, if that's okay. I heard I have 12 months.
It's a 12-month program at minimum. There might be,
Starting from when I, like, last week.
Starting from when you signed it.
yeah, it was like, I think,
Oh, wow.
April 13th, or it was about a week and a half ago.
Is that okay, Judge? That,
Sure, I mean,
can you try to remove me? I mean, I want to be in college by the time I get out, and I'm growing up now. I'm not gonna be enough of it, I promise.
all right, so here's,
I'd be out at the bus stop.
let me just tell you the way things work.
My first
Yeah, no problem.
wrong people, wrong crowd at outside, you know.
So let me tell you the way treatment programs work. And specifically this treatment program. This treatment program is a pretrial diversion program. So what that means is if you complete everything, it's not going to be on your record. If you decide, you know, this program is too much for me, I think I can do it on my own, then what will end up happening is your case will go back to an originating court, and they will proceed with those charges, whatever those charges are.
That's what we don't want.
Yes, people in your life, because I'm very like manly, because we grew up late always, and I'm old, and I was self-defending myself, but I was still in the wrong for being in that situation. I shouldn't be voting. I shouldn't be outside. I shouldn't have a cigarette in my lip. And now that I'm going to school, my mind is developing like if I'm in the 12th grade. Now I'm older. And my mind is a lot younger. Like the things I should have done at 18, I was hurt still. I did at 24. And it just, I look back and I say, I can't really have delays. No, I don't want to delay. I want to get my education. I want to go to college. I want degrees. I was looking into psychology, sociology, math, science, business administration, business management, data analysis, computer science.
Well, I will tell you, this is a program this program will work with you on that.
That's the only way. I learned the hard way. 10 years of me out there, it was no good for me.
Yeah.
That's why anything you ask, I'm willing to tell you a lot about it.
Oh, thank you so much.
Yeah, I'm not hiding anything from you because my family, they're cops, they're in the army. I made a terrible decision to go to the streets. I didn't join the gang. I didn't do any of that. I never shot anybody, I never stabbed anybody. I never robbed nobody. I never did drugs. I just am like a kid that went out when the parents said, my parents on church, they said, don't go out. I went out. They said, don't go over there. I went over there and I got in trouble a lot. And the first confession, and that had a lot of my education. I was hurt.
Well, what I can tell you is this program.
I was hurt, but it's better than that.
Well, I will tell you, this program is to help you get on track, and we want you to be on track, okay? So what I'm gonna do is I'm gonna reset you, and you wanted it when?
If we could respectfully judge, May 15th, that's his mental health court setting.
All right, so we're gonna reset you for May 15th, okay? And when you come for that setting, I'll remember, my mind's a steel trap. I'll remember everything that you told me. But this is what I want you to do. When you come on May 15th, let us know what your schedule is for school so we can see what we
Monday
can do.
to Thursday, anywhere from 9 to 8 p.m.
Okay.
Usually works out.
So with meds, may I get a Zyprexa note in there because the Zyprexa is the real lighter one?
Here's the thing, what you'll need to do is you need to talk to your doctor because I'm not a medical doctor. You'll need to talk to them. I always tell people if there's any issue with medications, side effects or something of that nature, talk to your doctor because I'm not a medical doctor. Okay.
I nothing really mentally. I don't need medicine, but I'm spiritual. I love God. I know to do the right thing will be good guy. And that's all I ever tried to be. Like I can promise you that. And I'm so sorry for coming before you in this position in life. And I know you're a great woman. You have a good heart, and I appreciate everything you're doing for me.
No problem. And thank you so much. And like I said, where we are in life, we're all of us are trying to improve. Like I'm on my path of improvement. We just try to do make improvements every single day, and that's what you're doing. So I appreciate it. And I want to let you know, I see that you're doing that.
You gave me the light of the day today for the rest of my life.
Great opportunity for you.
Oh, thank you.
Yeah.
Does he need a reset form or would that help? Would you be helped by having a reset form?
Yes, if the court wouldn't mind, Judge, just so I guess he has the paper with
No,
him.
we could just for reset form for the 15th.
Maybe you can.
Yes,
Maybe excuse me.
yes, thank you. All right, who's ready?
Ready, I have page 2, Judge, next one down, Christine Moreno.
Hey, do you have, can you make me another copy of the docket? Thank you.
All right, we may check back in with Judge Boyd later. We'll see, but let's go back up to Judge O'Donnell in Ohio.
Your Honor, we're here in the matter of the state of Ohio versus Melissa Jenkins. This is case 26 CR 113. Ms. Jenkins is present in court. She's accompanied by her attorney, Mr. James Matthews. We are here today for a change of plea, and the state has agreed that we would move to amend count 1 from a felony of the 3rd degree to a felony of the 4th degree, thereby making the possession of heroin felony of the 4th degree. And with that amendment, it's my understanding she will tender a plea of guilty to that charge, as well as count 2, operating a vehicle under the influence of alcohol or a drug of abuse or a combination thereof, a misdemeanor of the 1st degree. We would ask for a pre-sentence investigation report.
Mr. Matthews? That is all correct, Your Honor. All right, Ms. Jenkins, how old are you?
51 years old.
How far did you go through school?
I graduated. I have my GED, Your Honor.
Are you a U.S. citizen?
Yes, I am, Your Honor.
Are you able to read, write, and understand the English language?
Yes, I can, Your Honor.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
I am on 75 milligrams of Zoloft, Your Honor. That's all.
And when's the last time you took that?
This morning.
Does it affect your ability to understand what's going on here today?
No, sir, not
Did you get a copy of this indictment?
Yes, I read. I've seen it.
My understanding, you're pleading guilty to the lesser included offense of count 1, possession of heroin, a felony 4, and also count 2, OVI, a misdemeanor 1. Is that your understanding?
Yes, Your Honor.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk some more to Mr. Matthews, let me know and I'll give you more time. Do you understand that?
Yes, thank you.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor. Are
you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, I do.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yeah, I do, Your Honor.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes,
Are you waiving that right?
yes,
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
yes, sir.
Are you waiving that right?
Yes,
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes,
Are you waiving that right?
yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to these charges?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, I do.
You understand by pleading guilty to the felony in count one, you're voluntarily giving up your freedom for whatever period of time I can sentence you to prison, to jail, or to community control.
Yes, Your Honor.
The lesser included offense in count one, possession of heroin, is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, Your Honor.
Count two, OVI, is a misdemeanor 1. It carries a maximum 180-day jail sentence and a maximum fine of $1,075. Do you understand that?
Yes, Your Honor.
The fine range is mandatory. It's from $375 to $1,075. Do you understand that?
Yes, Your Honor.
Do you understand that your plea on count one will result in a driver's license suspension of at least 1 year up to 3 years?
Yes, Your Honor.
Do you understand is that right, Carolyn?
On count two.
On count two,
Yeah.
what did I say, count one?
You said count one.
Okay, count two, the OVI, it's 1 to 3 years. On count one, on the possession of heroin, it's a license suspension potentially of between 6 months and 5 years. Do you understand that?
Yes, Your Honor.
There is this is a first-time OVI?
Apparently, yes, I know.
All right, there is a mandatory jail sentence of at least 3 days. Do you understand that?
Yes, Your Honor.
Any question about the penalties?
No, sir.
All right, if I gave you a consecutive sentence, which would be one sentence after another, the maximum prison sentence would be 18 months and the maximum fine would be $6,075. Do you understand that?
Yes, Your Honor.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes, Your Honor.
If you are placed on post-release control and violate the conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If the violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, Your Honor.
If that were to happen, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand that if a prison term is imposed in this case, you are eligible for judicial release?
Yes, Your Honor.
I could place you on community control on count one for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, Your Honor.
Have you had enough time to talk with Mr. Matthews before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions at this point?
No, sir, I do not.
All right, Ms. Mulligan, if the case went to trial, what would the evidence show?
The state would be prepared to show that on January 17th of this year, just after midnight, the defendant was driving on I-90 in Concord, Lake County, Ohio. A highway patrol officer observed her traveling at 30 miles per hour for no apparent reason and pulled her over. Later observed some indicators of impairment. She performed poorly on field sobriety tests, and she was arrested for an OVI. Chemical tests later showed that she was under the influence of a heroin metabolite. Upon her arrest, it was discovered that she had concealed in a body cavity a substance that was tested and confirmed to be 6.49 grams of heroin.
All right, Mr. Matthews, anything to add to those facts?
No, Your Honor.
Ms. Jenkins, did you hear what Mr. Matthews said, or Ms. Mulligan said, the facts would show if the case went to trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
What is your plea to the lesser included offense of count 1, possession of heroin, a felony 4?
I'm guilty, Your Honor.
And what is your plea to count 2, OVI, a misdemeanor 1?
I'm guilty, Your Honor.
Matthews?
Thank you, Your Honor. Prior to the hearing, I did review the guilty of Ms. Jenkins. She indicated that she understood it and that she intended to sign it. Date on this line, 4/30/26. And then sign on it.
Your Honor, Ms. Jenkins has signed the written plea of guilty for her signature.
Ms. Jenkins, is this your signature on the written plea of guilty?
Yes, Your Honor.
Did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
I'll accept the written plea of guilty. Defendant was present with Mr. Matthews, advised of all of her rights, being a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequence of the guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept your plea of guilty and find her guilty of count 1, the lesser included offense of count 1, possession of heroin, a felony 4, and count 2, OVI, a misdemeanor 1. I'll refer this for a pre-sentence report. And a drug and alcohol evaluation sentencing will be June 10. And at 10 a.m. and the bond is continued. Anything else, Ms. Mulligan?
No, Your Honor. Thank you.
Matthews?
No, Your Honor. Thank you.
All rise.
Alrighty, friends, let's head up to Michigan. We'll check in with Judge DeSanto this time.
State your name.
My name is Jennifer Berardi.
All right, good morning, and thank you for dressing appropriately for court. And counsel, today is a date scheduled in this matter for the arraignment.
We had a mini PCC also, Judge, today.
Okay, that's fine. Okay, we can address that also, but as to the arraignment.
Waive the reading, ask the court to stand mute. Can you repeat?
Okay, well, waive the formal reading. Ma'am, you do have the right to have an attorney. You're unable to afford an attorney, you may ask for one to be appointed to represent you, and you have exercised your right to retain your own counsel, correct? All right. You also, ma'am, have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say or in writing may be used against you in court. Do you understand those rights, sir?
Yes,
I'm sorry, ma'am. I was looking at Mr. O'Brien. Okay. And the court will enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference. Well, first, counsel, are you waiving time?
We'll waive all the time requirements, and Judge, I will be back here in 2 weeks with a request for an exception on a previous case, and Mr. Rardy thinks 2 weeks would work. We're going to make application here to the mental health court docket. May I have a pre-screen today to meet individuals?
I don't know that we have the ability to do the pre-screening today. But we can, you can contact Courtney to see what that date would look like. All right, and so then Ally?
There should be no unnecessary delay if we're here in 2 weeks. This is a true third, the low breathalyzer score, and clearly there are other issues that need to be addressed by the court. And you agree, right, Pam? You're gonna get that 20 day when you like to apply for mental health for
Yes.
right? Very well done. By the way, apologize for her
Sheriff was speaking in court.
I apologize about my friend talking. I apologize about that.
They were actually signing the form where they were paying for the forfeiture on the car and he was explaining it to her. They shouldn't have done it to the court, Judge. I apologize.
I appreciate that. Okay. Ally, what's our date?
May 14th at 8:30.
Perfect.
May 14th at 8:30 a.m. All right, as to bond.
Judge, she has voluntarily turned herself in. This arrest took place some time ago when the warrant came. She presented herself to the court.
Yeah, they gave me a PR.
Wait, just,
Only your attorney speaking right now, ma'am.
and that's because they had blood drawn. They didn't have any evidence at that time. And at this point, Your Honor, we'd ask for the usual terms. If you think testing is necessary, you should know that she's basically indigent. So whatever you do or subject her to, I would think if it's testing, I don't think she can afford to tether. I think she should be tested. And the usual terms for the bond, I'd ask for a substantial personal bond. I know she doesn't have the resources.
Okay, and so, ma'am, if you test right now, what's in your system?
Nothing.
You have prescription drugs?
And take prescription medications.
Okay. And so, when's the last time you consumed any alcohol?
February 4th, my arrest.
Have you ever failed to appear in court for any reason?
Never.
All right, given the nature of the charges as being a third offense, the court needs to ensure the protection of the community. So what the court's going to do is the court's going to order a $25,000 personal bond with the following bond conditions. You're not to possess or consume any alcohol or drugs unless prescribed. And then the court is going to have your client participate in random testing. So ma'am, you're going to go over to probation where you'll get a copy of your bond conditions as well as information regarding your testing. Okay?
No drugs, no alcohol. You don't have a marijuana card, right? You don't smoke
No,
marijuana.
just my prescribed medication.
All right, we'll have her give a list of probation what she's taking. Judge, thank you.
Thank you. All
Thank you so much.
right.
Have a great day.
All right, thank you. You as well. All right, let's go off the record for a moment. Counsel, what matter are you here on?
I'm here in violation of probation. I'm here. Judge, I'm
Gary Williams. Okay, yep, I have that right here. Okay, and then Mr. O'Brien, then we have you.
Yes.
Okay, let's go on the record in the matter of the state of Michigan versus Gary Williams, 25839.
Thank you, Your Honor. Craig Padlock, here on behalf of Mr. Williams, who's approaching the podium. In lieu of his attorney of record, Julian Buda, sir, do you have any objection to me standing in for Mr. Buda? No.
All right, counsel, I need you, well, hold on, counsel. I need you to place your P number on the record.
P56669.
Okay.
Padlock. P is in Peter, A is in Victor, LFCK.
Oh, Pavlock, as I said,
Yeah.
Padlock. Okay,
Okay.
all right. And so, sir, your name for the record, please.
Gary Williams.
Okay, so today is the date scheduled for a jail review as well as a probation violation. This court had sentenced your client to 10 days jail, serve 5, suspend 5, as well as probation at sentencing. And so it appears as though your client was charged with driving while license suspended, as well as testing positive for alcohol on April 13th for the positive test. And so, counsel, as to that allegation.
Thank you, Your Honor. I've had the opportunity to go through the allegations with my client. Obviously, testing positive for drugs, alcohol, not drugs. Back on April the 13th of this year, he's intending to enter a plea of guilty with regard to that. He also has the driving while license suspended that's pending. It is set for, at this point in time, June the 16th in the city of Troy. Judge, I've had an opportunity to speak to him about this. He's not denying the fact that he had tested positive for alcohol. He wishes to enter a plea of guilty at this time, obviously, because the pending criminal offense is still to be determined. He does admit that he was charged with the offense of driving while license suspended.
Okay,
Judge, and I'll address sentencing at the appropriate time, obviously.
okay. Sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Much louder, please.
Yes.
Okay. All right, and sir, you heard those allegations that were placed on the record, correct?
Yes.
As to those allegations, sir, how do you plead?
No contest to the driving unsuspended and guilty to the alcohol charge.
Okay. And and you have gone over your advice of rights with your attorney, correct?
Yes.
As to probation violation, your rights for probation violation hearing, and you understand all of those rights.
Yeah.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
You understand as well, sir, that there'd be one technical violation being entered and one non-technical violation being entered. Do you understand that?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And counsel, if you can please voir dire your client.
Sir, back on April 13th, 2026, is it true that you had consumed alcohol and tested positive when you had gone for a test for the ETG?
Yes.
And obviously, you're pleading no contest for driving license suspended. At this time, you're not disputing the fact that you're perhaps involved in an operation of a motor vehicle at this time, and it is pending in the Detroit District Court. Correct. Judge, please satisfy her.
Okay. The court is also satisfied the plea is known, voluntary, and factually accurate. The court will accept your plea to the violations, indicate technical violation number 1 for the positive alcohol test and technical violation number 2 on the driving while license suspended no contest plea, and counsel as to sentencing.
As the sentencing judge, I've had an opportunity to speak with Ms. Shaw with regard to the sentencing recommendation. I would just ask the court, obviously you suspended 10 days. You suspended 5 of 10 days when you sentenced him 6 months ago. He's been on probation for 6 months. He's completed almost everything. He's still in counseling right now for alcohol, substance abuse. He has approximately $1,000 in fines and costs left to pay for this court. These are serious violations, and he will address those with the court. He's very remorseful at this time. Judge, he's also a master plumber. His job right now has a great contract with Utica Schools. They're going to be there at the Utica Schools doing plumbing work through the end of May. Obviously, he's a single dad with 2 kids, 1 a minor. I would just ask that you consider, since 1 is a technical violation, consider perhaps 5 days instead of 10 days. I know it's a lot to ask for an individual you have in front of you. He's facing, this is his 3rd drunk driving, being quite frank and honest with you, Judge. He will address why it is or what the circumstances were with regard to his violations. Obviously, it's the impact that could possibly happen with regard to if he served the full 10 days and how it may impact his job that he can explain. The other recommendation from probation is 60 days alcohol tether. And as you know, there's an expense associated with that. But primarily what we're looking at is an individual that has a substance abuse issue. He clearly, unfortunately, violated your terms of probation by consuming alcohol once again. The alcohol tether will prevent that. I would ask you to consider, instead of 60 days, perhaps doing 90 days. It is an expensive thing. He's got a really good job. And the goal here for obviously for him is not to lose his job. And he is throwing himself on the mercy of this court. He doesn't have a lot of things to offer because of the violations that he's facing at this point in time. We will be representing him on the matter that's in Troy. I would leave to my client to address the court as well.
Okay.
Judge, with regard to jail 2, if you do impose jail time on this, I would just ask that you allow him the opportunity to turn himself in with well on a day other than today, just because he does need to make arrangements for his minor child and also the possibility of maybe moving things around with his employer to see if he can continue as soon as he's released from jail.
Okay, so I'm going to make a few comments and then I'll allow you an opportunity, sir, if you so choose. Your original charge in this court was a high BAC. You're 0.323. OWI and driving without license suspended. The high BAC was dismissed. The driving while license suspended was amended to a no ops. This court ordered 10 days jail, serve 5, suspend 5. Gave you a report date. The court also ordered, in addition to the conditions that this court put forth, additional mandatory incarceration for any probation violation. And you're here with a positive alcohol test and another driving while license suspended charge. Okay, which that's significant as well. But what this court's most focused on today is the positive alcohol test. Because, sir, you, if I recall correctly, are the sole provider for your children and the sole caretaker for your children, correct?
Yes.
Because their mother passed away, correct?
My daughter's mother.
Your daughter's mother passed away. Okay. So do you think your daughter wants to watch another one of her parents pass away?
No.
Then why aren't you getting it together?
One thing I would like to say, Your Honor, is when I started on probation, I was very optimistic about my sobriety. It's something that I wanted for at least 2 years, that I seriously wanted. And something that I put off, I shouldn't have. So that it was an opportunity that I was gonna have to face that. And I took it very serious. And I can say that I was just shy of 9 months sober. And before this, I probably couldn't tell you that I was ever 9 days sober. So I am proud of that, and I am disappointed.
Yes, you should be. You should be proud of that, sir.
Thank you. And but I am disappointed. I did have a weak moment. I will tell you, I did not drink in excess. That's still no excuse for it. I know I wasn't supposed to. I'm not gonna make excuses for that. I know what was against me. My daughter is graduating from high school right now. I really screwed up. I understand that. I'm back sober, been sober. I plan to stay that way. I feel that I should be held accountable. I want to be held accountable. I want sobriety. So all I can ask you is to give me that opportunity to prove that and to take care of my kids.
So what did your daughter say? Does your daughter know that you violated probation?
Yeah, she knows I'm here. I didn't go into too much with her about it, but trust me, she wants it as well.
What did she say to you?
About violating?
Or about drinking?
She doesn't like it, Your Honor. For sure. That's something that has come up in the past as well, before any of this has taken place. And that's a change that I want to make. I want to make it for my kids. I have done my kids very well over the years, and it really takes me back that I could have even done better. So I can't change the past, but I can change the future, and that's what I want.
And so what happened, sir? You said you started off probation, wanting sobriety and whatnot. What happened, that you tested positive for alcohol on April 13th?
I've been working on in counseling, finding what triggers, I've had depression over the years, so I've been working on that. I guess I didn't really think about it until after is that, I believe my work schedule right now, I've been working evenings. So I haven't been home as much as I want. I think I kind of went into a depression. And that's something I have to work on.
Okay. And so what are your work hours, sir?
Right now, we're working 4/10s. We're generally starting, sometimes we start at 2, sometimes we start at 4. We're working in schools right now, so it depends on when the school gets out. And so it could be from anywhere from 2 or 2 in the evening till about midnight.
Okay. And so are you sad that you're not at home with your daughter, or is that you're not having as much time with your daughter? Why does that make you sad that you're not at home in the evening?
That's basically it. When I took this project, I didn't realize what it was going to do to me mentally. Honestly, I seen my son a few weeks ago and it looked like he'd grown, and I felt like I'd missed that. So I didn't realize the effect it was gonna have on me.
And so how long is this project?
May 29th is the end of this project.
Okay, and when did it start?
I believe February.
Okay, so it's a short temporary
Correct.
time, right?
Correct, yes.
So you work 4 times, that means you're off 3 days.
Yes,
Okay, so on those 3 days, do you see your children? What is it you do on those 3 days?
yes, I do, yes.
Okay,
Now, my son is with his mother on the weekends. I take care of him through the week.
okay,
So I have not had the opportunity to spend a lot of time with him. And I think that,
did you have a conversation with his mom about maybe doing a temporary swap?
we do that in the summertime.
Right, during your project time?
No, I did not.
That may have helped you, I don't know.
And it very well could have.
Right. Okay. So what I'm going to do is I'm going to follow my order that I've indicated during sentencing. And sir, let me just say this, that it is an accomplishment for you to have been sober for 9 months, right? And I understand that it is a difficult challenge that you accepted and that you did very well on. So now the next challenge is to remain sober and acknowledge that you really can't drink any alcohol. So, even for the sake of the relationship with your children. And it's also notable, sir, that you are wanting to be held accountable and you're not offering excuses, and you're owning up and acknowledging your mistake. So what the court's going to do is the court's going to order on the jail review. The court's going to order the 5 days jail. What I'm going to do, sir, is I will allow you to report tomorrow. Oh, wait, when do you work Monday? Is it Monday through Thursday?
Yes.
Okay. So I will allow you to report tomorrow. You can serve 3 days. Then I will allow you to report the following weekend to do your 2 days.
Well, Friday,
What did I say? The following?
well, you said the following weekend.
Oh, yes, Friday, yes. On the probation violation, the court's going to order you to continue and complete all terms of probation. The court's going to order an alcohol tether through the Wayne County Jail. Report for the tether on May 15th. Going to order 5 days jail, suspended. Any questions?
No.
All right. So you're going to go over to probation and you're going to receive your next steps. Okay, sir?
Right.
All right. Good luck to you.
Thank you, Your Honor.
Thank you.
Alrighty, friends, that will do it for this morning. We'll be back tonight on this channel for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Do join us for that. It is the last Thursday of the month, which means the chat controls the topics. So y'all need to show up so we got something to talk about. We can answer your questions. We can discuss any cases that interest you, whatever it may be. So arm yourselves with ideas and join us again right here on this channel. And we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. Hope you all have a good day. We'll see you soon. Take care. God bless.